Number one. Why to be mentioned, Mr. Chatterjee?
It's not come at our instance. The affidavit
It's
is,
an interim order, no?
yes.
Is that expiring?
No. Till disposal of the application. Maybe it has come in the normal course.
Till the disposal. I'll be
Oh. On that date, it appeared under the heading to be mentioned. The day order was passed under the same heading.
It can be disposed of as
Ah.
under to be mentioned also.
Affidavits have been filed.
Affidavit, the university has served a copy, but late.
You have not prepared.
The central government has
So
not.
you prepared a paper book. Prepared a paper book incorporating the stay application and the affidavits exchange. Then in disposal, stay application, pending residency affidavits. Who is your other side?
Mrs. Mojumdar and
She is here.
for the central government, Mr. Animesh Mukherjee and Sri Kumar Chakraborty. The university stand is that they are merely implementing the policy of the central government.
So we pass it over, let Miss Mojumdar come.
Mr. Chatterjee, you inform.
If he is around Malan, I will definitely come. But here, Malan,
No, today we will dispose of the stay application. We will extend the interim order till disposal of the appeal. And we will ask you to file
Paper.
I'm trying to contact Ms.
Yes, bring them. That would be.
pass over করে রাখ।
Number two.
Two empathy appeal. The state launch. Filing affidavit in reply connection with the application for condonation of delay.
$42 days. 642 days.
Filing see paragraph number 7, page 19 of the application for condonation of delay. The petitioners are advised by the learned advocate on record not to prefer any appeal during the pendency of the appeal before the honorable court, namely Priyanka Noskar. Paragraph number 7, 6 and 7.
নস্কর।
This is a primary.
First order in Priyanka নস্কর। Order.
Lordships.
Lordship, there are 32,000 matter.
32,000 matter.
Lordship was sitting with Justice Sitopoto.
Honorable Justice Ritur Proto.
Oh, now why you have come?
No. This is another matter. This is another matter, my lord. What has happened? Our order is passed in the on 10th April 2024. What has happened? Thereafter, we did not prefer any appeal. because during the pendency of the Priyanka Noskar matter,
10th April
24. At
So
that
what was your writ petition about?
writ petition, my lord, we are the candidate, my lord, belonging opted districts Malda. We participate in the recruitment process of 2016. What has happened? We, in the recruitment process, no merit list was published. Now, my lord, we did not know our marks. But in the year of on 28th November 2022, the marks of the all recommended candidate, irrespective of all districts, has been published by the Secretary, West Bengal Board of Primary Education, wherefrom we get the marks of the successful candidates whose names are recommended. Thereafter, on 23rd May 2023, the West Bengal Board of Primary Education published a cutoff. Cutoff means the last candidates who are given appointment in the each district in respect of all categories. That was supplied to us on 23rd May 2023. After getting two information, we came to know that our marks in the district of Malda is higher than the marks of the appointed candidate. And admittedly, I can show before your losses.
Admittedly, বলুন।
According to us, I have the document to show because our marks, my marks,
No, very good. Your marks were above the appointed
candidate
Now, that you came to learn in 2023.
2023, when the cutoff was published.
So you were before the single judge. You did not say a single
Kindly
word.
see the impugned order.
Uh,
Kindly see the impugned order. Impugned order.
we have seen the impugned order.
Impugned order. Well, I have stated.
Where is your in read? Now, so your writ petition was dismissed on the ground of delay.
Delay. But kindly see the ordered impugned ones.
Where is your writ petition?
Writ petition annex from page 32.
How many persons are before us?
Before us, these are the
All the
Thirty.
petitioners.
all
40.
32.
32.
32.
Petitioner 40. Now 30 has come before us.
Before us.
32.
32.
So you have made the others pro forma respondents.
No.
Then it is a defective appeal. Stamp reporterটা কি করছে আমি বুঝতে পারছি You have not added them as party respondents.
No.
32. You have not added.
এইটাই।
এই যে এখানে বলেছে।
But normally it
Do
is
not
that-
find place.
ও হ্যাঁ। Do not
This is
find
the
place.
defect.
but defect
But
has not
clear-
been cured. I don't.
You have to cure this
Cure the
defect.
defect. You are to cure the defect. Who will?
I am not informed that the defect.
আর কি inform করবে? You select some persons, file the appeal, and leaving out others. You have to implement them.
As pro forma respondent. You
And
have to-
serve upon them.
হ্যাঁ।
And the order impugned, it is stated that we have a knowledge from, we had a knowledge from
ও
in
আগে
year
ইয়ে করুক না, হয়তো আমি
immediately in
দিতে
the year
পারবো।
2024.
না, না, নেই। ও আচ্ছা।
Where is the opposition?
What
to
is
the-
the opposition?
To the opposition to
Oh.
the section 5.
নিজের কাছে নিয়ে বস।
I am served with a copy
আমাকে
of
একটা
the-
কপি দাও। তোরা তো খেয়ালও করিস নি।
In the opposition, they have stated the ground of the opposition is that
Okay, we cannot proceed with this defective appeal. You cure the defect. Okay, delay part that be taken in consider, but it cure the defect, you include their name as pro forma respondent, complete service and then come.
by the order or impugned, the honorable single judge dismissed my appeal on the ground of
Appeal not,
accused
petition.
petition.
The learned advocate on record of the appellate Mention upon completion of service.
Mediation. If I am for the writ petition and appellant,
You have served.
so this is my affidavit of service.
Nobody is appearing. First time it has come.
Lordship,
আস্তে আপনি কি বলছেন বলুন।
আচ্ছা, আমি ওখানে বললাম যে
Lordship, along with the order of the copy of the,
কমিউনিটি
I have communicated the last occasion, Lordships fixed the matter on 8. That has been communicated also along with the stay application.
বললো সাইন দাঁড়ালে
Also here in this Lordship, the
Judge. Your other brothers are parties? No.
Lordship, this appellants.
Moon Bhattacharya. Who is Moon Bhattacharya?
Moon is the Lordship, the wife of the Lordship, the brother of deceased employee.
Wife is the wife
Wife of the brother of the deceased employee. Lordship, the brother of the original petitioner. Lordship was the teacher. Initially, Chandranath Chatterjee was the writ petitioner, who was the brother of the original deceased employee.
What is the name of the deceased?
Yes.
His name is Siddhinath Chatterjee.
Siddhinath.
Yes. Now, original.
Siddhinath.
Yes.
So he was the assistant teacher.
He was the assistant teacher.
Then
Now, his appointment was 18.
now when did he retire?
No, he's expired.
Expired when?
13 January 2002.
Died in harness.
Died in harness.
2002.
Now, his service was appointed in 18 January 99. His service approved on 23rd March 99. They expired on 30 January 2000.
13th January.
13 January.
Now then what happened?
Now, Lordship, the mother of the deceased teacher, Lordship, submitted application for pension. Another, Lordship, the
Name of mother? Name of
mother of the
Nomita Chatterjee. Nomita Chatterjee.
Nomita Chatterjee.
Siddhinath died leaving behind his mother, Nomita Chatterjee, two sisters, Bandana and Devjani,
Nomita Chatterjee.
and one brother, Chandana.
Now, Nomita Chatterjee expired on 19th May 2040.
January 2009.
কথা বললো এখন জিজ্ঞেস করলো কার
এখন বলছি এখন বন্ধুদের কথা বলি যেটা সার্টিফিকেট করেছিলেন
He was not given family pension.
No. Now, Lordship,
Nomita was the wife.
wife is Munmun.
Nomita, who is Nomita is the mother.
Nomita is the mother. Expired on 19th May 2040. Now, Lordship,
Who died on 11 January 2009? Nomita,
Mother died.
mother to Nomita.
yes, mother died on 19th May 2014. 1-4.
Then who died on 11 January 2009?
In your writ petition, come to page paragraph 3. You have written.
Very good. Then what happened?
Now, Lordship, the deceased teacher survived by Nomita Chatterjee, mother, Bandana Chatterjee, sister, Chandranath Chatterjee, who is the original writ petitioner, subsequently expired, and Devjani Chatterjee. Now, Lordship, Munmun Bhattacharya. Munmun Bhattacharya was the wife of the deceased teacher who subsequently remarried.
Munmun was the wife of Siddhi.
Yes. Subsequently remarried.
Divorced.
No, remarried. After death, she
Or
remarried.
after death.
After death, she remarried. And she also exonerated her claim, Lordship. That is the admitted fact. Now, Lordship, I filed an application for succession certificate. I means original writ petitioner, that is Chandranath Chatterjee. Now, Chandranath Chatterjee got the succession. In exclusion of Bandana Chatterjee and Devjani Chatterjee, who are the sisters, other heirs.
In your succession, you got the succession.
I got original writ petitioner.
When did you
Chandranath
get
Chatterjee.
the succession? When did you get it?
Succession certificate, I got it 13 November 27.
13 November.
2017.
Very good. Then what happened?
I filed the writ petition in 2020. I means, Lordship, the Chandranath Chatterjee since deceased.
Writ in 2020.
20.
And when did you expire?
Lordship, I expired. Chandranath Chatterjee mara gala tha. During the pendency of the writ petition expired.
Who stood substituted? Who stood substituted?
Wife and two son.
Siddhi, Chandranath's wife and two sons.
Yes. That is the Ranu Chatterjee, petitioner, appellant number 1. And Tranbak Jogi and Suchandra Chatterjee. That is the son and daughter.
One son,
Chandranath Chatterjee
and daughter. And what was your prayer in the writ petition?
Yes. Now, Lordship, the
But you were
my
the brother,
threefold
Where-
prayers.
were the son of the Chandranath was the son of the deceased.
Son of the brother of the deceased employee.
Brother of the deceased employee.
Chandranath Chatterjee is the brother of the deceased employee.
Siddhinath Chatterjee.
And Bandana and Devjani were the
Sister.
daughters.
Sister of the deceased employee.
Why Siddhinath had no heirs, no son, daughter.
Only wife subsequently remarried. Munmun Chatterjee was.
Then why was your claim rejected? Why was your claim rejected?
Yes, no, claim has not been totally
Was
rejected.
not considered. So you writ petition on what ground? Now tell us.
My writ petition was 3 prayers. One is the accrued pension, which was in favor of the mother, supposed to be disbursed in favor of the mother till her death, provident fund, gratuity, and interest. Now, Lordship, Honorable Single Judge, Lordship granted provident fund and gratuity amount in favor of the petitioner. So this part we are not challenged. Kindly come to the last portion, the penultimate paragraph. So far the provident fund and gratuity is concerned, we got. We are not challenging. Paragraph 1 and 2.
Family pension you will not get. That is
No,
right.
Lordship, this is the family pension which
Mother-
was supposed to be accrued in favor of the
Mother-
mother of the deceased teacher. Now, Lordship, the mother of the deceased teacher, as per the report which has been submitted before the learned honorable single judge,
নমিতা 2002 থেকে
Lordship, Nomita Chatterjee who expired in
2009
2014.
2014
No, 14, you are again saying 14. You come to page paragraph 3 of your writ petition. You show the death certificate of Nomita.
Nomita Chatterjee expired, that is not dispute.
Oh, to ascertain the date of death.
Nomitaর মারা যাওয়ার ডেটটা।
জানি।
Lordship, in the
Yes.
report.
So your
Yes.
statement
Oh, yeah, Lordship.
statement in paragraph 3 is
Page 49,
not
kindly come.
true. Now page 49 is 2014.
Yes, Nomita Chatterjee, 19 May 2014. Nomita Chatterjee.
Now what you have written in paragraph 3 of your writ petition?
2009 লেখা আছে।
Huh?
Lordship, I'm sorry. Lordship,
It's written as 2009.
49.
Yeah. 9th May 2014, Nomita
Now, Lordship,
died.
this is subsequently corrected in my,
In my copy, that has not been correct.
yes, it's in copy.
So now you are claim that from the date of death of Siddhinath to till the date of Nomita,
Family
the family pension is supposed to be released in his favor, to
Yes.
have been released in
Now,
his
Lordship,
favor.
kindly come, the rule 2S of the DCRB scheme, 1981.
Did Nomita ever make any application for?
Yes, initially submitted application.
Where from we will come to know?
It has been, Lordship, in the impugn order, it has been stated that Nomita initially submitted application.
Whether Nomita will be entitled to family pension or that is also a factual aspect.
Yes. Now, Lordship, this is the issue. Lordship, this issue, the Honorable Single Judge has not been dealt with. Kindly come to the impugn order, two paragraphs, paragraph 16 and 17. Page 99 of the inner page 9. So far as the family pension is concerned, as per clause 5S2 of the scheme 1981, the brother is not to be considered as eligible. Therefore, in the event the death of a teacher, in this particular case, during the pendency of the writ petition,
Why
the
it has been substituted?
substituted. We are the substituted at present.
Aha. Deceased teacher's wife she stood substituted. What is his wife has been substituted as the petitioner.
Yes, petitioner is the brother, and the present petitioner is the wife, son, and daughter of the original writ petition, who has expired.
Now, how the wife of a brother will be entitled to family pension?
So I am not claiming family pension for the petitioners or the brother. I am praying for accrued family pension, which was supposed to be disbursed in my mother.
Right,
In
he
the mother.
claiming the arrear pension
Very
of the month.
That is from the date of death till the date of the Nomita
No.
Chatterjee. Lordship, the mother was entitled to family pension.
No,
No, one
as
thing.
because the
one
wife
thing-
is there.
One thing,
Till his remarriage,
The
he
wife
didn't.
yes, maybe after remarriage I am entitled.
Remarriage was on
remarriage in 2003. Remarriage
Remarriage 2003, yes.
2003, I have got it.
3 to 14, my mother was entitled to family pension. She applied.
Oh,
Now her application,
on the date of death of Siddhinath,
yes,
it is the wife who was substituted. That means why acquired entitlement to receive family pension
yes,
on that date.
yes,
There's a why shall exclude the mother.
yes. On that
Thinking is class 1 years.
Yes.
Class 1 years will exclude the class 2.
family pension statutory right. I am not going to the Lordship
Okay.
Succession Act.
So had the wife not married, wife would get family pension.
Obviously, absolutely.
Obviously.
Yes, yes.
So if wife was alive, mother would never get family pension.
Now,
It is admitted.
That is admitted fact.
admitted.
Yes.
Now, the mother can claim that as and when the wife has remarried, I have acquired a right to get family pension.
That is my case.
Cannot.
I have a right to get family pension. Now, what the learned court has
Kindly come page 16 and 17. My mother's right has not been considered. Only considered the petitioner's right. Now, Lord, in the report, now in the
So
report,
her rights stood extinguished or lost since the wife married. Wife rights to get family pension stood extinguished since he remarried.
In your writ petition which you filed, that is Chandranath filed the writ petition.
yes.
So did the wife of Chandranath's brother join him in the writ petition?
So I'm sorry.
Chandranath was the brother.
Munmunjan.
So my brother is right that up to 2003, question of getting any family pension by the mother did not arise because the wife was there till 2003. That is
Yes.
still remarriage.
As a widow.
So if any due has occurred, that due is pertaining to
Moon Chatterjee.
Mun.
pertaining to Nomita is from 2003 till she expired. That is 2014. This is the period. Now, when Chandranath preferred the writ petition, was Nomita a party along with you?
Chandana Chatterjee preferred the writ petition in 2020.
Right?
Nomita expired in 2014.
Very good. There was no claim made by Nomita prior to her.
Nomita, Lordship, prior to the writ petition, Nomita submitted application for pension.
Where from we will get?
Yes, that is
Nomita did not pursue her claim. Nomita left the claim. That is why when you filed the writ petition in 2020, at that time Nomita had expired already. By that time, Nomita had expired in 2014.
Yes.
So the right extinguished.
No,
There
Lordship,
was
the
no claim to
initially the
family
writ petition was filed.
There was no claim to family pension. Now, the single judge has observed, who happened to be, has also died. In this case, his wife, who is the wife of Chandranath, who is the wife of Chandranath,
So Chandranath means present petition.
who is the wife of Chandranath.
So wife of the Chandranath is Ranu Chatterjee.
Now, Ranu got substituted in place and stead of Chandranath.
Yes.
Now,
So, Nomita was never in the picture. Nomita neither did make an application for pension, since at that juncture the wife had not remarried. When the right accrued in favor of Nomita, Nomita did not say anything.
Now Nomita has applied for pension.
No, that how
When?
you
When?
show us that
Immediately.
Nomita had approached. Nomita did not ventilate any grievance.
grievances.
Now Nomita did not file a writ petition. But he wait for
Your right goes. We cannot revive a stale claim and say you pay the arrears.
No, I Lordship kindly see when my succession application.
No, forget about everything. Tell us, Nomita, you filed the writ petition in 2020. At that time,
Previously I filed a writ petition that was consideration order. 2017. It was.
that was considered.
It was.
Order was passed.
Order was
Order was passed for
That
consideration.
order was challenged.
No, on the basis of the order, Lordship, the kindly come page 42. 42, 43.
আমরা এখন এসব শুনেছি।
Oh, yeah.
42.
42 is a succession certificate. That apart, you have not,
Sorry, page 51.
you have not annexed the schedule.
A writ petition of
Succession.
2070. That is also after death of the.
একটা লোক যদি তার বাড়িটাকে স্বর্গ করে,
Forgo করে,
সেখানে
সেইটাই।
application learned seeks to leave supplementary evidence leaving in view concern. Then what was the final order? This was the earlier writ petition 1739. Acha, then where is the final order?
Now, the
The writ
Lordship
petition was disposed of.
disposed of.
Oh,
Page 43
so Chandrona's writ petition
was disposed of.
take into account relevant documents as provided and process the claim of the. Now, what is the order pursuant to that order?
Yes.
This order, Lordship, this is page 46.
46 na,
Oh,
51.
after
No,
50,
sorry, page 55.
আবার বলে
55, 55.
Page 55.
now
That
this-
was the observation of the Assistant Director of DPP that some compliance has to be made. This is the requirement of compliance.
চন্দ্রন এখানেও ভুল করেছে চন্দ্রনাথের
এই ওটা বার
প্যারা
করতে হবে।
7টা দেখো দেয়ার আফটার
ওখানেই
চন্দ্রনাথ
বলা আছে।
may be eligible for the lifetime arrear of family pension of his mother কি করে of his brother's wife হবে
Subject to government বিচার।
subject to
No, মাদার ঠিকই, মাদার সেই যে বিয়ে যেদিন করলো, যেদিন বিয়ের ডেটটা আমিও এখানে আগে লিখে রেখে দিয়েছি।
lifetime arrear of family
ফ্যামিলি পেনশন অফ
his mother আচ্ছা
মাদার, মানে ওই যেদিন
Mother
থেকে
মানে
12/3,
নমিতা।
নমিতা ওই 12/3 হচ্ছে ডেট অফ ম্যারেজ অফ রিম্যারেজ অফ
এবার
ওই মুনমুন।
what happened after this তারপরে nothing has been done.
Subsequently, Lordship, the several this compliance already made. Now, Lordship, kindly come. Page 58 is the death certificate. Kindly come page 59. That is the additional treasury officer Bolpur issued the certificate that Nomita Chatterjee used to get the pension of her deceased husband 8283.
Yes, yes.
Now,
pension নিয়ে চলে গেছে
So
Now, this is the
Nomita,
pension of the Nomita's husband.
Nomita's husband.
হ্যাঁ
Yes, yes. I admitted fact. Page 63, it is also same document.
husband
Now, Lordship, kindly come to
the-
the
নমিতার হাজবেন্ড বলে কিছু
Mother is already getting the pension of his husband.
ফ্যামিলি পেনশন ফ্রম দ্য সার্ভিস অফ হার
Mother used to get the family pension
অফ হার হাজবেন্ড,
her deceased husband. Her husband,
ফ্রম দ্য সার্ভিস
the-
অফ হার হাজবেন্ড।
সার্ভিসে তো অন্য লোক
ওর স্বামীও চাকরি করতো,
সে তো বলছি অন্য
সিদ্ধিনাথের
লোক।
বাবা।
সেটা সব ঠিক আছে।
নমিতা ফ্যামিলি পেনশন পেতো
You
ওর বাবা।
satisfy us from 2003 till the filing of the first petition in 2017. Did ever Nomita come up and claim family pension?
yes, Lordship, kindly come to the report page 85. That is the report of the DI.
No, where is Nomita application claiming that I shall get family pension from the service of my son Siddhinath?
ওটা ক্লেমই ছিল না। Once a family pension is on the event of date of mother of the
Lordship, kindly come page 88. That is the report of the DI. Lordship, that's a there's a report of the DI in this. Lordship, strictly in terms of that school authority forwarded the application for family pension of Nomita Chatterjee due to her deceased son. Lordship, this is paragraph 10. Page 88. The school authority approached to this office for family pension in favor of Srimati Nomita Chatterjee, mother of the deceased teacher, but this office did not receive the same due to incomplete submission of the papers. Now, Srimati Nomita Chatterjee, mother deceased, subsequently expired in 19 May
Mr.
2014.
You are not answering our question. You show us one document that Nomita made application or claimed family pension. If that is not there, you have no right. Not only you have also expired. Now your wife, your heirs are now saying 2003, my grandmother was there. She was entitled. Now I will make. It is a stale claim, Mr. Stale claim.
Now, Lordship,
যা
this
পেয়েছো
is
তা নিয়ে satisfied?
admitted fact is the mother applied for pension.
Oh, wait. In your writ petition, any statement made that your mother applied, that the mother of Siddhinath applied?
I got one document in his favor, but it shows otherwise. School has forwarded the claim of the wife, that
Munmun.
Munmun, And that was informed to his mother
Uh,
that wife is already applied.
এরকম অনাদিকাল ধরে
That is annexure P3 of the writ petition.
এখানে আমি পরে
That is annexure
whether
P3.
family pension is like a property.
যে হ্যাঁ, it is
It will
not
No, no, statutory right.
Pension is a
This statutory right, I'm lordship.
whose statutory right?
The wife's statutory right
আরে the
subsequently
wife
mother,
did not claim.
the mother has
She
claimed.
did not claim ever.
Mother has claimed. Lordship,
Kindly understand, Mr. Mukherjee. Munmun was in the
lordship,
picture.
they,
Munmun was in the picture till 2003.
yes.
He expired on 13th of January 2002. Her husband,
Yes.
Munmun's original husband, died in 2002, and she remarried in 2013. So from 2003. Now from 2003, did Nomita make any application for family pension? Say my son's wife has remarried. Now I come within the purview of the definition of family pension. Family pension ma pabe to.
Yes, Ma is there.
Ma is there, but Ma was sleeping. So you cannot be it. Ashok,
No, lordship, kindly allow me.
abar ki kindly.
Lordship, kindly.
Are it is not it is Mr. Mukherjee, try to appreciate. Family pension is not a property right. Family pension is given in terms of a scheme.
Lordship, with this order has been passed without interest. I'm entitled to get the interest also.
Interest.
Right, the disease teacher expired in 2002.
So your first ground goes. Now your second, what is your argument?
Without interest, the authority has been directed to disburse the amount.
Interest is not a interest is dependent upon the facts and circumstances.
Yes,
Where is your prayer in the writ petition?
kindly see, there is a prayer of the writ petition, 12%.
So. That prayer was made by Chandranath.
Chandranath lordship, this is during the pendency of the writ petition expired. We have been substituted.
My lord, in that regard, my lord, I have to make a submission.
So yeah, no,
Kindly come the prayer.
no provident fund
12%
gratuity has
I have
been
paid.
released upon death of Siddhinath to anyone.
My lord, that is apparent from the report.
Concession certificate
And my lord, there is an audit observation. My lord, it is page 46. There are 9 observation has been made, audit observation.
That is the prior to the writ petition.
Thereafter, my lord, it is forwarded to the pension sanction authority. Pension sanctioning authority written to the school authority to comply with this.
Paragraph 6, what did you say? 6 observations.
My lord, 46, page 46 of the stay application.
So these documents we have annexed, lordship, that is the before the honorable single judge. But in spite
There
of that,
is
all the order has been passed in our favor.
এই প্যারা 7 থেকে দেয়া যায় প্যারা 7 থেকে অ্যাসিস্ট্যান্ট ডিরেক্টর নিজে বলছে যে ও পাবে
আমরা বলছি না যে পাবেন, but the right has extinguished.
কোথায় দেখলাম
Lordship, kindly come page 25 of my.
ওকে আর একটা কোথায় দেখলাম you come to page 88টাতে who read this রিপোর্টটা দিয়েছিল
এটাই
counter affidavit on behalf of respondent number 3 district
Para
DI of
12.
school
Para
para
12.
10 you come to page para 10
Approach করেছিলেন।
school authority approach to this office for family pension in favor of Nomita
আছে টাইটেল সেই যদি না চায় আমি তাকে
School authority-
And my lord, when the school authority submitted 18,
School authority সুমোটো approach করেছে
তাই
document showing
88,
your
page 88.
succession right to succeed, the pension and other benefit,
First,
that cannot be attributed to the state authority.
then, my lord, school authority submitted the return on
Mother
18, para
alive
12.
till 2014.
Mr. Mukherjee, show us one document your mother applied.
Lordship, kindly come page 25 and 26.
No, we will not go by statement. You show us that
Yes,
your
document.
25.
25 and 26 of the application.
25.
It's the prayer portion of the writ petition. 26 is affidavit.
Page number.
You
Lordship, kindly
claimed
34.
interest.
Lordship, kindly 34. এটা কেটে দেবে।
হ্যাঁ, তো ধরো ওটা ধরেই গেল পচা মামলা নিয়ে।
পেজ 34 এটা কি? দুটো পেজ নাম্বার কেন এটা কেটে দেবে।
Be happy with what you have got, Mr. Mukherjee.
Lordship, the interest I am very much entitled.
Interest, when did your right crystallize?
Lordship, to my
After you
mother,
obtained succession, 2017 you obtained succession. School forwarded in 2018.
Lordship, the school
Audit observation 2019. Pension
Audit
paper,
observation is 2019.
pension paper was,
observation, that is
pension-
that is
pension
Lordship,
file was
audit
given to the school
observation,
authority
that is the
with
administrative
compliance. My
process.
lord, all papers are annexed.
Now,
Now, when did the school comply?
audit observation and
My lord,
school
kindly
lordship forwarding, that is
46.
the administrative process.
Paro,
Lordship, the petitioner is not at fault. Lordship, for this reason, Lordship, the petitioners cannot be precluded from getting the benefit. Because this is all an administrative process.
34 page.
Mr. Mukherjee, pension is a benevolent scheme. The money which is given by the government is not to be, it is not like a blessing which is given.
Lordship, so for the provident fund amount
There
is
is a
concerned,
question. A provident fund amount, how the authorities will take a decision? Your succession was in 2017. So 2018 school forwarded, school audit observation 2019. Then it was given to the school. Then you filed the writ petition. Your writ petition, this writ petition was filed in 2020.
no, 2017.
No, 2020.
Subsequent writ petition.
17 was the first writ petition.
Yes.
That is after your succession, maybe. After you obtained the succession, you came in the picture.
The succession I had received on 13 January 2017.
2017.
Yes,
When did you
January,
file?
November
Acha, when?
17, November 2017.
November 2017.
Prior,
Now, just a moment. And you filed the writ petition on 16th March 2020.
no, what's the previous writ petition?
Previous representation was 2017.
Yes, June,
That
prior
was-
to this order of June 2018.
And crystallized into an audit observation in
Lordship,
2009.
the audit observation for that fault, Lordship, the petitioners cannot be faulted because petitioner is entitled. And so far, Lordship, pension is concerned, kindly come page 31, that is the forwarding of the school for granting pension to the mother of the original petitioner.
That is school statement.
Yes, we have admitted paragraph number,
Page 25
paragraph
and
number 10 of the report.
Did Nomita ever come?
So, Lordship, this is the headmaster. After the death
Uh-huh.
of Nomita, Lordship, the headmaster has issued a letter that Nomita is entitled to get the family pension. And Lordship, on the
The
basis of
situation was such in the peculiar case that succession, production of succession certificate is was necessary. Because here the employee or assistant teacher died, leaving behind him his wife, and he was issueless. Now wife remarried,
Two daughters,
yes.
two sisters. Married sister.
In that circumstances, it is inevitable that that the person concerned would be asked to produce the succession certificate. Now his inability to produce the succession certificate or the period lost for obtaining succession certificate from the competent court cannot be attributed to the state. Interest can be given when there would be a delay on the part of the state. That yes, you have delayed, you have caused delay. But here, whether due to this delay, state can be held responsible.
পুরোটা পড়েছো?
Well,
And
kindly
even
shift
Lordship,
paragraph number 12 onwards. We have explained how his pension file was forwarded.
now, Lordship, this
My lord, page 88.
And you show any application that after my daughter-in-law
Paragraph
remarried,
onwards.
I acquired the right to get family pension
this application.
of Nomita from the service of my deceased son, namely Siddhinath Chatterjee. So the actual right was of Munmun.
Yes, Munmun remarried.
Munmun has
Remarried.
voluntarily
Surrender.
surrendered such right.
The present appeal has been preferred.
Now, Lordship, only one thing. Lordship, the succession, the application after the succession by Lordship, page 26, submitted on 16th April 2017. That is page 35, 17.
Hmm.
Now, Lordship, even up 27 to till date, this amount has not.
Oh, you made a succession, you got, when did you file the writ petition? March 2020. Writ petition was filed?
Writ petition, Lordship, my representation is sufficient.
Oh, no.
Well, Lordship, I filed the representation for disbursement of this family pension.
Be happy with what
Even
you have got.
17th to till date, nothing.
But you also, Chandranath was also sitting on the fence because there was a decision. In fact, his primary objective, come to the prayer, his primary object is to get, come to prayer in, service benefits, death in harness, provident fund, pensionary amount of his mother, no specific statement as regards the family pension, arrears of family pension.
No, I am not paying for Lordship at present. Lordship, let the family pension. Lordship, so what the interest is concerned.
Interest we are explaining.
17th, Lordship.
17 was the writ petition, first writ petition.
Yes.
Thereafter you obtain the succession certificate.
No, so succession certificate prior to
Now
17. Prior to 17.
This is
Sorry, November 17. And succession is not required also. Lordship, I don't know why the DI has, Lordship, advised them to get succession. Regarding family pay, Lordship, the retirement benefits.
Be content with the same.
Lordship, kindly consider.
Okay.
your junior is smiling.
Okay.
The present
17 to till the disbursement, because till
Mr.
it-
Mukherjee, kindly consider state, in our state, this person family pension benefits are all benevolent expressions of a scheme. You are not, it is not a case that a widowed mother is lying on her deathbed. Unless the money comes, there will be no treatment for her. Your heirs, brothers' heirs have come upon being substituted. After that, since Chandranath made a prayer for interest, now you are saying, give me the interest. We are in appellate court. Court has exercised discretion in a particular manner which we do find to be absolutely unreasonable. Ashok, the present appeal has been preferred.
Lordship, the amount has not been disbursed till now, Lordship. Kindly stay.
Oh, it would be disbursed.
Mr. Das,
My lord,
Disbursed.
comply with the order.
my lord makes such observation, immediately comply with.
Lordship, kindly record my
We
submission.
make observation, it will march with our order. Contempt will be before us. The present appeal has been preferred, challenging the Immediately file a contempt. Immediately
Lord,
go and file a contempt.
Lord,
Have you
I
filed
am
the contempt?
exhausted. See, in 2014, I am doing application. They are not
After
bothered.
this order, they will. But appeal was preferred by you, na? So immediately communicate this order, Mr. Das, put in a word.
Okay.
Surely put in a word.
Already
Yes,
communicated.
next matter. Oh, Passover. Ische?
I can talk, my lord. She is likely not to come today. She is requested for her not today. She will be there tomorrow.
She has not come.
Okay, not today. Item number 1, not today.
Item number 4.
My lord, I am for the appellant petitioner.
The board, my lord.
I'm mapping for secondary board, your lord.
The appellant petitioner participated in the second state level selection test, my lord, for the subject economics for classes 11 and 12 under
HLST.
yes, my lord. For classes 11 and 12, subject is economics. My lord, in the month of September, my lord, when the preliminary vacancy position was declared, my lord, the total number of vacancy for subject economics was 506.
Yes.
Thereafter, my lord, before verification process starts, they have published the final vacancies. In the final vacancies, the total number of vacancies remain unchanged. That is 506. Well, surprisingly, my lord, in category OBC B, which the appellant petitioner belongs, the total number of vacancy in Bengali medium male-female category, it was previously 27. But in the final vacancy, my lord, it has come down to 25. Well, under the statute, my lord,
Quota cannot be reduced.
yes, under the statute, I am entitled to have 7% of vacancy for OBC B category. Well, that has been reduced. Previously, this appellant was in OBC A category, my lord. Thereafter, after the reclassification, my lord, he has been placed in OBC B. And in OBC B, if your lordship kindly,
Classification was prior to this election.
reclassification was, the notification was prior to the selection, my lord.
So you applied as OBC B.
Yes,
So
on my part, there is no fault. I am OBC B now.
So the only case is whether they can reduce the percentage or not.
Yes, my lord.
What did the single judge say?
The single judge did not consider the grievance, my lord. It only considers that I have approached in a belated stage. So my reply to that, my lord, that I have approached the court only after finds that adverse consequences of the reduction. Immediately after publication of panel, I have approached the court. And till date, no third party right has been
Panel was published when?
in the midst of January, my lord.
In 2026.
Yes. The verification is of 25th of November 2025.
When did you apply?
Apply in the month of July 2025. When I
So you were called for verification.
yes, I am a successful candidate in the written qualification and I have been called for verification.
So you were called for verification.
Yes.
Now, what is your position in the panel?
Yes, my lord. Thereafter, my lord, interview held in the month of December, precisely on 22nd December 2025.
Interview.
After the interview, my lord, the panel was published in the month of January 2026. I am waiting list category of candidate serial number 3 in male female
OBC B.
OBC B male female category Bengali medium.
You are at waiting list
3.
So OBC B male female category is 27. Was 27.
Initially.
Because initially It was final vacancy was 25.
Yes.
So you knew about this thing.
Oh, my lord.
27 final list is 25. You must have known
My lord,
there are two stages of disclosure of vacancies. First is the at the time of that কত rule আছে না?
at the time of advertisement, there was no declaration of vacancy.
When was it declared 27?
In the month of September 2025, after closures of applications form.
September 2025. Final list was published. Final vacancies.
Preliminary vacancies,
That is 27.
27.
That was published when?
September 2025.
September 25. And final was published in?
Third week of November 2025. Now, if your lordship kindly consider one
You
thing,
have come at least then. 3rd November you got it reduced.
my lord, your lordship will kindly
But
consider.
thereafter you participated. You were called for verification on 22nd of December 25.
My lord, my approach before this Honorable High Court
What
is,
to have been at that juncture, Mr.
my lord, may I reply to this, my lord? My lord, a aspirant may not come to this Honorable Court in each and every aspect, my lord.
Otherwise considering the ambit of the selection process, everything gets disturbed. Now panel has been published.
Panel,
If we accede to your prayer or we allow you that window, today it will be having the effect of topsy-turvying the entire select list.
certainly not, my lord. May I reply to this, my lord? My lord, I have approached this Honorable Court immediately after publication of the panel, my lord. My lord, when I approached the Honorable Court, my lord, no third-party right was created. No verification process started. Even today, my lord, for my subject, economics, my lord, no verification has been started.
You just
There
now
are
said verification done, you are now in the waiting list.
no panel published. The counseling, sorry, my lord, I stand corrected, my lord. Verification, no counseling has been started, my lord.
So
So
when was the written test?
written test in the month of July 2025, September 2025.
So after that you are not called for verification?
Yes, I have called for
When?
verification. I have called for verification in the month of November 2025, 25th of November 2025,
And you had called for interview?
22nd December 2025. My lord, will you kindly consider, my lord, in
Now
each
panel was published in January 2025. You filed the writ petition after publication.
3rd of February 2025. Immediately after I get affected for the reduction, my lord.
Yes, what is your explanation to this?
Only one thing, madam, may I add? Your lordship will kindly consider one thing. In Hindi medium, they have not reduced, they maintain 7%. In Urdu medium, they have not reduced, they maintain 7%. In Bengali medium, female category, they have not reduced, they maintain 7%. Only in Bengali medium, male female category, they reduced it below 7%.
In Hindi medium?
In Hindi medium, total 7% comes.
No, so, and what are the other?
In Urdu medium also.
Urdu and
in Bengali medium, female category,
yes,
they have maintained more than 7% in all these three categories. But in Bengali medium, male female category, my lord, it comes down to less than 7%. And the 100-point roster itself says that I am entitled to get 7% of the total vacancy position.
On that day, we pointed out that kindly comparative reading of page 64 and 65.
64 and 65, my lord.
65. In
Well,
65, it was most probably at the time of advertisement.
This is the final, yes.
No, 64 is tentative. Tentative. There, general candidate, general, you are was one, SC was 51, and OBC now for this S, reduce, SC 1 reduce.
Yes.
What is the reason?
In SC, my lord, there are
On that date, we stated that the authority is not powerless to reduce. They can increase and decrease. But what is the reason? Oh, Mr. Bhattacharya, what is the reason?
My lord, may I, my lord, I am appealing.
SC has been
I may be allowed to appeal partially.
or file a short report or
My lord, I may be allowed to appeal partially, my lord. My lord, may I answer to the queries of your lordship?
yes.
Lordship, my junior is there, my lord. We will hand over two chart. Kindly hand over the chart to your lordship. My lord, I'll explain, my lord. There has been no reduction in the vacancies, my lord.
Yeah.
My lord, yes, my lord, kindly see the number, serial number 1, unreserved. You are, my lord, you will, my lord, will find in male, female, that was tentative vacancy was 160, female 27. Thereafter, your lordship, the second column, that is the vacancy of 1 male, female, and 1 female. Appointment was given to the in-service candidate as per the direction of the Supreme Court. So, my lord, here from the 160 male female tentative, it was reduced to 159. And
Yes, yes.
female 27, it was reduced
Closing your stand.
Ah,
to 126. Thereafter, my lord, the third column, my lord, or
Madam, you file a short affidavit explaining your stand.
lordship, lordship, lordship,
You can
lordship, lordship. Not 2 days, only one week may be given. 1 week.
1 week.
1.
as a can one. Having heard the learned advocate appealing for the respective parties and upon perusal of the materials on record, we are of the view that this application needs to be decided after exchange of affidavit by the parties. In view thereof, the respondents are directed to file affidavit in opposition to this application being can 1 of 2026 within a period of
to 1 week.
1 week. Reply thereafter if any be filed within a period of 2 weeks.
Yes, my lord, I shall.
Within a period of 1 week thereafter, place the matter for further consideration.
Kindly fix the date.
3 weeks since.
3 weeks.
Affidavit in opposition or a report may be filed, your lordship.
File an opposition, covered the points.
Lordship, lordship.
On
Sir, may I
5th,
take
you can take
The petition has,
that.
the first petition is 28 January.
It will be on merit, Mr. I come late. Delay has been taken as a for rejection of my petition. It petition is maintainable.
Yes.
Delay
It's not been
তাই একটু
paid by.
ঢোকাতে হবে। That
Okay, we are
Deeply obliged.
Yes, next.
No, 5 I am for the board lordship. It is that matter that medical ground transfer 5 years. The main matter is fixed at 3 p.m. lordship.
Today.
Today it is fixed at 3 p.m. Item number 17. So let this be taken up at that time because the issue is same.
That's the content fix আছে না? All right, we will call at that time. সেদিনকে দেখো।
Lordship 5 to 8.
5 to 8.
8.
I am for the state, my lord.
ঠিক আছে, next number 9.
Grateful.
Secretary Ashish Kumar Chaudhary. I'm filing the affidavit in reply. But I'm filing the affidavit in reply and serve the copy.
When? You have not served.
No, today I'm serving. A similar matter, your lordship was fixed this matter. A similar matter was fixed in 21st April 2026. Your lordship.
21st April.
April.
They have filed the opposition.
Yes, sir. And I'm filing the reply.
Lordship, in item 9, I am appearing for the commission led by Dr. Patra, my lord.
Mr. Jana, you are Mr.
I'm Rohan Pal, Advocate Rohan Pal.
Pal. Mr. Pal and the advocate appearing for the appellant files the affidavit in reply. Copies you have given. Let the same be kept on record. Let copies of the same be served upon the respective respondents. Stop. Mr. Pal submits that a similar matter has been fixed for hearing on 21st April 2026 and prays for enlistment of the present matter on the said date. In view thereof, list the matter for further consideration in daily supplementary list of this court on 21st.
Grateful, my lord.
Lordship last order records that kindly take some order dated 5th March 2026 passed by your lordship. 5th March 2026. Second page, second last paragraph. Last chance was given to the respondent, writ petitioners.
Delays of how many days?
Around 2,458 days.
2000.
Because the writ petition order was passed ex parte without serving on us.
Why haven't you filed your?
Milord, I have filed, Milord. I am for the respondent number 13, Milord, DPI.
So you are for your.
Writ petition was given last chance to file reply to our or other opposition to our application.
Writ petitioners.
Yes.
Bunch
of petitioners were directed to be regularized.
You have filed your opposition. That is state.
Filed.
So you
I am for the DPI, Milord.
DPI.
Director of Public Instruction.
So they are not coming.
Yes, initially they were not coming. Direction was given to serve upon them. Yes, he is representing now. He is now representing.
So what you had it? You had a talk with him?
No, today no.
So what do you want? We proceed.
Lad, I can inform him and come back anytime. If Lordship takes up today, in his absence, I do not want to let it be.
If the opposition has not been filed, they must be filing
on several occasions. Time was given on. Kindly similar last few orders. I'm led by Mr. Mazumdar.
Yes, Mr. Mojumdar,
Yes.
we are told by your junior that writ petitioners have not used an opposition.
And for time and again, your lordship has been pleased to grant them opportunity to file opposition against our section 5 application. In fact, the last order, if your lordship can
So give a notice, come back on 13th.
in the meantime, my lord, they will proceed with the contempt.
Contempt, is it in the list?
I am told,
No,
my
not in the list.
Not in the
Not in
list.
the list.
Contempt has been posted for
But my
hearing
lord,
on
now, my lord,
26th.
yes.
They have recorded, they have
If
said that
this
we
is
have
my lord,
recorded that.
today they cannot use any affidavit, having regard to your lordship's order. Your lordship was pleased to give them last chance.
All right,
That is recorded in the
your junior says that he will, I don't know, he was submitting that. If you can get hold of Odunava Banerjee, bring him.
Yes, madam, sorry. I'm sorry, madam.
Odunava Banerjee.
My lord, is appearing.
I'm trying to
The lordship may kindly take your lordship first order and the section 5, this order which has been appealed against was passed in 2010. The petitioner before your lordship is my lord kindly take assume charge in 2017. Immediately.
No, if we hear you, we have to proceed, na?
Yes, my lord. I leave it to your lordship, my lord, because my lord, if you get hold of
come back on Monday. Come back on
Monday, no, not Monday, my lord.
Why not Monday? Monday, you have to come.
Possibly, my lord, there would be a resolution.
Traveling, but I will be not on vacation. Therefore, some other reason I will be traveling. That's it.
We cannot appoint CDI to the CID to that effect.
My lord, yes.
Obliged, my lord.
Item number 11. Who is there?
Your Lordship, I appear on behalf of the appellants, Your Lordship.
Yes.
On the last occasion, Your Lordship was pleased to grant the liberty to file the list of dates and events, Your Lordship. Here is the list of dates and events for Your Lordship's consideration.
What are the applications? What are the applications?
Yes, Your Lordship. This is an application for recalling the order dated 24th September 2015, passed by the Honorable Division Bench, presided over by the Honorable Justice Debashish Kaur Gupta in FMA 832 of 2004, arising out of MAT 2568 of 1999, Your Lordship, which had also preferred against the dismissal of writ petition being WP number 12103W of 1999, Your Lordship. My lord, this writ petition was filed by the petitioner seeking a direction of...
It has been restored or not?
No, Your Lordship. This is an restoration
Go a bit
application.
slow. Let us
Yes.
see where is your. What is the number of your restoration application?
Yes, the 1524 of 2020. It was filed on 28th January 2020, Your Lordship.
And you have filed a section 5 along with this?
Yes, Your Lordship.
What is the number of that?
Can 5 হবে?
Can 5 কি?
1525. 1525, section 5.
Have you served copies?
Yes, Your Lordship.
Where is your affidavit of service?
On the
Who?
On behalf of this, on behalf of the respondent,
Okay.
appeared on the last occasion.
Jawaharlal De.
Can 1525/2020 is the application under section 5 of the Limitation Act, Your Lordship.
How many days delay?
2124 days, Your Lordship.
2124.
In filing the restoration. So what remains in the matter?
Your Lordship, the
Dismissed for default on 24th September 2015. And you filed the restoration application
20 সালে?
20 সালে।
Hmm.
The learned had no knowledge of dismissal of the appeal for default.
The order নেই বোধহয়
Your Lordship, the difficulty was the Honorable Court, the division bench of the Honorable Court directed to file the paper book, Your Lordship. We have filed the paper book on the concerned department, but they were never served upon by the department, Your Lordship. As per the Rule 41 of Appellate Side Rules, Your Lordship, which states that when a case is ready for hearing, the officer in charge of the judicial department shall furnish the advocates engaged on either side with the copies to which they are entitled under Rule 49 or Rule 53, and the issue of the paper books to the advocate shall be noticed to them that the
But it
case is ready for
An informal paper book.
this rule is for both the informal or formal, Your Lordship. May I peruse the rules, Your Lordship?
So paper book will be filed by the appellant.
Yes,
Huh?
Your Lordship.
And if it is not served, then you can sleep over the matter. Huh? Paper book was filed by you and it got dismissed. You
Yes.
filed after 2000 some days,
We have
taking a plea that the office did not send it to state. So
Your Lo-
state did not appear.
Your Lordship,
But what happened with you? Why
Your Lordship,
didn't
we had
you appear?
Your Lordship, we had no knowledge about the same.
So that is your fault. You are not sincere. The appellants will sleep and you take a point or Rule 41 of appellate side rules. Where is the order impugned? Which order have you challenged? What is the date of that order? 99 order. 99 order.
No, Your
In
Lordship.
writ petition, appeal was filed against which order?
Your Lordship, order dated
Yes.
24th September 2015, Your Lordship.
Wait, that is the dismissal for default. Which order you preferred appeal?
Yes, Your Lordship, against the WP number 12103W of 1919, it was dismissed on 25th June 1919.
But 20 minutes. Come to page 103 of your paper book. Place the order.
No, Rule 40 is applicable in respect of a paper book prepared
Rule 41, Your Lordship.
appeal from original duties,
Yes, Your
degrees.
Lordship.
Whether you said that formal and informal paper book, in both the paper book, this rule applies. You satisfy as Rule 41 of appellate side rules is applicable to informal paper book filed in writ proceedings. What is that? It is part 2.
Yes, Your Lordship.
Part 2, you see, you saw that informal paper book which is directed to be prepared by the petitioner, the part 2 of appellate side rules is applicable.
In one part. Paper book is in one part. And as per rule 40,
You are giving this instruction to the junior. You are giving this instruction. You being a senior, you are giving this. In writ proceedings, there is a writ rules.
I'm hard of hearing, that's why my junior is doing it. I can't.
So it is.
To my question. Excuse me.
So don't give any wrong information to the juniors.
হচ্ছে যে আপনি আমাকে ডাইরেক্ট করছেন সেটাই আমি বলছি, তো সেটা বলছে ডাইরেক্ট করছেন সেটা আমি বলছি, সেটাই বলছে।
When court directs preparation of formal paper books and the paper book is deposited, submitted to the department, then the duty of the officer of the department will come to inform the parties that preparation of paper book is complete. But when informal paper book is prepared,
Formal and formal both are filed.
you saw that it is applicable for informal paper book.
49 says so.
You saw from the rule.
when the case is ready for hearing, the officer in charge of the
Which
judicial
paragraph
department
it is, which
shall
which
unveil
chapter it is?
41, I'm reading 41.
Before that, 41 part of which chapter?
Appeals for original.
41 position.
Part 2 appeals from original degree is
And whether it is an appeal from, it is from appeal from original degree.
Withdraw করে নিন
99 এ 36 ইয়ার্স ছিল, এখন কত? 99
এই ground
11 বছর,
Your
21
Lordship, I am praying liberty to file the fresh application, Your Lordship,
Huh?
withdrawing the same.
No, no. Only on this ground it would be this. For making wrong submission in the court. Or trying to mislead the court.
61 বছর বয়স হয়ে গেছে। To the main matter, come to the main matter. তখন তো কিছু নেই তো, স্কিম চলে গেছে, পার্ট টাইম অ্যাপয়েন্টমেন্ট, 20 বছর ধরে মক্কেলগুলোকে ঝুলিয়ে রেখেছে। এখন বলছে আমরা রেস্টোরেশন to the main matter. Are you ready with the main matter?
No, Your Lordship.
Huh?
No, Your Lordship.
You're not
Yes,
ready.
I am prepared, but I am not prepared for hearing the main matter today.
Yes, you argue the main matter. What right you have? There are 4 writ petitioners. Tell your senior after we make this. There are 4 writ petitioners. It appears one person has already, they have already crossed 60 years of age.
Yes, Your Lordship.
Today, after they have attained 60 years, can we direct them to be regularized? Number 1. Number 2, the scheme under which they were allegedly appointed, that has also not been extended.
The other employees have been transferred to elsewhere, but we have not, the remaining employees.
Sir, it is very difficult to, there has to be a spontaneity. Either you argue or you allow your junior to argue.
All right.
You advise your junior, you prepare hard, survey notice upon the other side and come back. Tell us, when can you come?
After 2 weeks, 2 to 3 weeks. Your Lordship.
Ground for delay, have you said
What
anything?
was the count? Why we shall? Where is the explanation?
Para 7 or para 8?
You are prepared with section 5 application.
Yes, Your
Huh?
Lordship.
So tell. Why we shall hold the cause is sufficient? Tell.
Your Lordship, the matter is we are not aware that the appeal was already been listed and it was dismissed for
How?
default.
You had no advocate? Did you not engage any advocate? They must have had advocates.
Yes,
You
Your
were
Lordship.
there. Why didn't you?
My
keep
learned
track?
senior was there.
Your senior was there. Then in 2 paragraphs, 3 weeks sense করে দাও। আর combined list এ দেবে? 3 সপ্তাহ বাদে দেবে। Just call the next matter. হ্যাঁ, ও হ্যাঁ।
ফর্মাল পেপার আমি সঙ্গে সঙ্গে বার করে দেখলাম এটা একটা অ্যাডভোকেটের চেম্বারে হচ্ছে। আগে তুমি ডিপার্টমেন্টে এই ব্যাপারটাই জড়াও।
Item 12, কে আছে 12 এ?
Lordship, item number 12, I am for the petitioner in this matter. I am for the petitioner in this matter, Lordship. Petitioner has died on 14 July 2025. Accordingly, I am praying before your Lordships for filing substitution application. Petitioner died, Lordship.
Petitioner or appellant died?
Appellant died.
Yes, appellant.
Jutika Das died.
Yes, Lordship.
Jutika Das died.
Yes.
Substitution. He wants to file substitution application.
Acha, Mr. Dr. Lanet, advocate appearing for the appellant, informs that during pendency of this appeal, the appellant has expired. Prays for leave to file appropriate application to bring the legal layers of the appellant on record. In view thereof, matter stand adjourned. Acha, let the matter go out of list.
Liberty to mention.
Liberty to mention.
Yes.
Grateful, Lordship.
Yes.
Item 13.
Item number 13, I am appearing on behalf of the appellant. My friend, Mr. Ratul Vishwas with Sannal, appear on behalf of the respondents.
Yes.
So, I am willing to place my case, madam.
You have no other option. You have to.
Yes.
Mr. Sannal is opposing you.
No. Sannal is appearing on behalf of the respondent.
Correct answer he has given. I never opposed man.
Huh?
He has said I am appearing for that. Your lawsuits asked him, Mr. Sannal is opposing. He said,
No, you never. Such a nice guy you are. Your mother, oh, you are not the effective respondent. Mr. Vishwas is the
effective respondent.
Mr. Vishwas is there.
Mr. Ratul Vishwas and with Mr. Ratul Vishwas.
He is senior, not junior.
Not
মানে আরো ঝামেলা।
Sannal with
বিশ্বাস থাকলে যদি কিছু বিশ্বাস করে তো বলো কি come to the order.
Yes.
Disciplinary proceedings on different charges are
110.
Honorable Justice Abhijit Gangopadhyay passed this order.
Who has passed? Where is the order, Mr. Gayan? Where is the order impugned?
110.
That is
110?
110. Yes.
Well, my brother has gone earlier to you.
110.
Yeah.
উল্টোটা দিয়ে দিয়েছে
Dog stop wearing.
এটা আপনার লেখা না আবার এইখানটা আমার লেখা
In this case, my lord, my
unauthorized absence.
Go and file why didn't you file statutory appeal?
My lord, there is no reason, according to me, my lord, subject to lordship's correction, there is no reason at all in this order.
Why do you want to lose a forum? Go to the appellate forum, file the appeal.
There is appellate forum, no doubt.
Then why
but
you are?
That is alternative remedy.
That
is the alternative remedy.
Right.
But I can, the writ petition, always we have filed the writ petition before this honorable court.
So you will not file statutory appeal. That is why you are angry.
Yes.
Place the facts.
I am not, I have not filed any statutory appeal.
No, that is why you are before us. You do not want to file statutory appeal. Yes.
Lord,
place the
what
facts.
I am saying, my lord, page 110, the order passed by this honorable court, that is not an there is no such reason. So far my knowledge is concerned, I have filed a writ petition.
Oh. Allegation is unauthorized absence.
Unauthorized absence.
On 14th June 2017 to 14 June 2022. Two 2020.
When I passed the writ petition, my lord, an order was passed by the Honorable Justice Sugata Bhattacharya. In the state order, a liberty has been granted to the DPSC Howrah to continue to complete the disciplinary proceeding. In the meantime, the court was directed to me to join. That is page 44. You will also kindly see the page 44. This is the order of the Honorable Justice Sugata Bhattacharya.
ট্রেনিং কোর্সটাও কমপ্লিট করে
অ্যাপয়েন্টমেন্ট দিয়েছিল।
হ্যাঁ
From this order itself appeared, and the council also admitted that no suspension order was issued, but they have issued the charge sheet and disciplinary proceeding has been initiated against me.
You were allowed to resume
Yes.
after justice.
After passing this order, I have allowed to
You have
resume the
been allowed.
duty. I have allowed.
And thereafter they proceeded with
Thereafter they proceeded with the disciplinary proceeding, and in the disciplinary proceeding, they have
terminated you.
Terminate me.
So
To removal from service.
So that disciplinary order is under challenge. You
Yes.
filed this
That disciplinary proceeding under challenge before this court.
but
Because of the fact
in this writ petition.
In this writ petition.
Very good. Then you argue you have been now you have been allowed to. When was the dismissal order passed?
The dismissal order passed on. You will also kindly see.
Yeah, we have seen that is at page 86. Page 86. First April 2019. এখন কত 6 বছর হয়ে গেছে। So you challenged this order and court said আচ্ছা তারপর সুব্রত দা একটা অ্যাপিলে অর্ডার পাস করলো পেজ 49 to 49
If your lordship kindly turn to page 92.
Ninety-two দেখাচ্ছ না 93?
92. The removal from service order by the issued by the chairman DPSC Howrah. My first point is, my lord.
So you received salary after the appeal
Yes,
court
yes.
order?
After passing the order passed by the Honorable Justice Subrata Talukdar, I have received the salary.
Achha.
I have
Yes.
received the salary.
Yes.
Lord, my first point is, my lord,
Sir,
page 92.
we wanted to tell you, Mr. Gayan, that your 2019 dismissal order was passed in 2022.
22, yes.
Writ petition which has been filed thereafter has been dismissed, saying that you can file a statutory appeal. The order impugned. The order which you have challenged in this writ petition, that is page 246.
246.
বোঝানো very difficult. Mr. Gayan.
Yes, my lord.
Page 246 you have come.
I have.
So High Court has said that no violation of natural justice, no jurisdictional error. So I am not inclined to interfere in the writ petition.
Yes.
Your remedy is to file a statutory appeal.
No, there is no, but super subject to lawsuit.
We will say, so today suppose after hearing you, we dismiss the petition, your appeal if it is dismissed, then into 20, where will you go? You will have to go to Supreme Court.
Yes.
So is it not better to take a chance that I will file a statutory appeal?
Right. But statutory appeal, so far my knowledge goes, my lord, I have seen in earlier occasions also.
You are not understanding what I am saying.
Yes.
Today, if we allow your application, well and good. But if we dismiss your application, you will be losing one forum, your appellate forum.
Yes.
So
that is
it
before
not
the Honorable
better-
Supreme Court.
Is it not better that instead of returning a finding on this, we tell you to file a statutory appeal? Which you will file and they will consider on merits.
Yes.
Not
On
limitation.
merits. Yes.
On merits they will consider and they will pass a reasoned order. If thereafter that order goes against you, avenues will be open.
Yes, if your lordship suggests me that
We are not suggesting.
No, we are not suggesting.
Because your opponent will jump up now and say, at this time, no statutory appeal. All barred, everything
no, my
gone.
lord.
He will stop.
Earlier occasion, Mr. Ratul Vishwas was also submitted that. To.
What is your choice now? What do you say?
If your lordship so.
If your lordship.
My fear is this, my lord. What I am understood, my lord, that DPSC, in the DPSC Howrah, the chairman DPSC Howrah passed this order. They passed the removal order. One of the member is DPSC, chairman DPSC is also the appellate forum. One of the member is DPSC chairman DPSC Howrah.
One of the members of?
One of the member of the appellate committee. That is the chairman also.
Yes.
So,
chairman has passed the order.
Yes, chairman has passed this order. Page 92, you will also kindly see that signed by chairman. Page 92. This is my only fear.
কাটা যাচ্ছে না।
Now, who passed the order? Where is,
86 to
where is
86
the order of punishment? Where?
89.
Page 89.
Page 89 starts, page 92.
Page 92. Yes. Who passed this order? Secretary?
No, Chairman, District Primary School Council, Howrah.
School Council, Howrah.
Yes. He is also a member of the appellate committee.
Okay. To whom appeal lies against this order?
Appeal
lies
before
to
the
whom?
appellate committee, where the appellate committee, one of the judges is there, chairman will be there, the chairman of the concerned DPSC will be there, and other 2 persons will be there. The 4 persons committee. So this is my only fear.
Okay, you take us to the appeal provision. A teacher may against a mention in Rule 8 to the appeal committee constituted under Section 91 of the Act. So take us to the how the appeal committee will be constituted, that provision. Appeal committee 92. You have not brought anything.
Page 91, section 91. Yes, Mr. Sandal.
Section 91, appeal
Who is
committee.
appeal committee?
The appeal committee, if I'm not wrong, your lordships, is headed by one of the retired judicial officers.
No, chairman is a member.
No. But I will take further instruction. No, chairman is not.
So we will say that he will file statutory appeal.
But
They
if that
decide
will
it on-
linger the procedure. Your lordships, go on merit, find him, reinstate him. That would be,
So
be
easy to
better, I
use,
think, your
very
lordships.
easy to use.
That would be better.
Difficult for us.
Give him relief if your lordships find at all.
For that, in fact, we are saying we will set us.
If
for
find
that
your
reason,
lordships,
I will
give him relief. Why you just relegate him again, appellate authority, second round, third round.
point.
Let him.
He didn't take the point. You oppose the writ petition. Why he has come here?
No.
What? No.
Well, that's one of the point usually taken.
Ah.
I think I didn't appear. I think I personally didn't appear. Yes, he was fit for that court. No,
We
no,
will
no.
dispose of the appeal. He will file the appeal within a specified time. Your committee. will-
That's your losses. One way your losses can wash it your losses hands, no doubt.
Not my
But-
hands.
But your losses go into the merit. Kyle is a teacher. He's a teacher. See the conduct of a teacher.
Yes, appeal
But
committee.
I'm off the record. I'm saying during this period, he continued with medical course.
But
In
there is a
Bihar.
provision. There is a
The
provision of.
But kindly
special-
look into this.
Yes, there is a provision of.
This is not, should not be a teacher. He entire
ordinary-
period he went to Bihar, stayed over there, and the primary school go on to astray. So look into the merit. If your losses commences to grant him relief.
You are pursuing medical course.
I'm not, that's off the record. I'm saying that's the case. But your losses will find even the medical prescription he has granted that has been dealt with by the inquiry officer. It's beyond my lord, when he was joining, he was in the school for the first 4 months. Even that period he was ill in Bihar. That sort of medical prescription.
The medical prescription that I have attacked with a
Admitted absence for long period.
I have not disputed.
Do you want to argue the matter on merit?
On merit, if your lordship,
But
yes,
you
no,
make up your mind.
Yes.
After we hear, then you cannot say, all right, my lord, now
No,
today give me an opportunity.
On merit, I can
Argue on merit.
There is a provision of extraordinary leave.
First,
Page
take us to the
99.
charge sheet. First,
Oh,
take us to
that
the
is
charge
another aspect of the matter. Court
has
dismissed your writ petition on the count that there is a no lacuna in the decision making process. And hence, there was no question to interfere.
There is no such reason.
So,
no such reason. In my writ petition, I have placed everything.
So you show that this observation is wrong.
Yes. 110. May permit to read it, Milord. There was a disciplinary proceeding against the petitioner on different charges. The charges were proved. The petitioner was given opportunity to file the representation which he filed. Thereafter, the chairman of the District Primary School Council, Howrah, considered the said representation and has observed that every opportunity was given to the petitioner for defending himself, and there was the violation of principles of natural justice and fair play, and therefore I cannot sit in appeal over the said decision of the chairman of the District Primary School Council, Howrah. I have not found any anomaly in the decision-making process, and therefore I do not think that that is the proper case where the court can interfere. This
Now,
order has been passed. But in my writ petition, I have stated in my writ petition that I have completed. Mainly they are going to the, if you will also kindly turn to 92, page 92, mainly they are going to the chairman, the disciplinary authority, chairman, they are going to the non-completion of my training qualification.
Oh, writ petition has been dismissed because why? Because every opportunity was given to you to defend.
Yes.
Was that no opportunity?
No.
There are
I have
to understand, Mr. Gan.
Yes, Milord.
There are three contingencies in which you can approach the writ court. Whirlpool, you have seen, there are three conditions. One, there is violation of natural justice. Second, there is a jurisdictional error. Third, there is the order itself is perverse and contrary to statutory provisions. Show us how those grounds are met.
But if your lordship kindly
First, show us where is the violation of principle of natural justice.
If your lordship kindly turn to page 99.
Yes, 99.
That there is a provision of extraordinary leave without pay.
Oh, court
That's the
says,
provision.
Mr. Gain,
Yes,
court
Milord.
says, I cannot sit in appeal over the decision of the chairman. And I do not find any fault or any flaw in decision-making process. Hence, read this dismiss. You have challenged this order.
Yes.
So you cannot invite a writ court to sit in appeal over the decision. So the next option left to you, there was a decision-making fault in decision-making process, and the observation of the learned court is wrong. And then hence, appeal right.
Yes. My
So
first
if you
point is
can
this.
satisfied that there was a flaw in decision-making process, then the only remedy is appeal, which courts refuse to sit in.
Yes.
So you go to the appeal, and there's that leave rule.
That's why I'm saying.
And such and such, and
That's
my
why I'm
medical
saying.
certificate.
That's why
So that
Lord, that's why I'm saying.
Justice Chakraborty initially gave what you will do. Go to appeal and you read this order, then you are good.
With off the record, in this, may I quote one of the honorable judge? One lawyer is asking for a relief. Kindly direct the DI to consider it. Your lordship knows the honorable judge very much, both of your lordships. Then the honorable judge replied, if I cannot grant you the relief, DI can grant you the relief. So this is the position. Your lordships find out the violation. If your lordships really find that, remand it back. But there is no such thing. There is nothing. My learned friend is asking your lordship to go to leave.
Yes,
It is not a matter of right. You admittably absented for a long
My
period.
right, my lord, to
Right.
get a leave.
Is the right.
This is my right.
Proceed.
That is the your lordship kindly see the
On
page 99.
Is the right.
Extraordinary leave is my right.
Scope of judicial review and scope of appeal is different. Why we shall?
Then I am compelled to show an order of the another high court, my lord. But there are several judgments has been referred, passed by the Honorable Supreme Court.
Mr. Gayan, you are arguing a matter. You will take us to the facts now. Judgment will come later. Show what is the charge against you. Come to the charge sheet. Argue on merits. You are arguing before us. Show us that. Show us. Come to the charge sheet.
My lord, my first point is this, my lord.
আবার বলে first point. Show us from the charge sheet. Come to the charge sheet.
Page 37. Unauthorized absence from 14 June 2017.
Not today. গতকাল।
Yeah.
Come ready. Not today. এই ডেকে দাও এদের। Come ready tomorrow. Come ready tomorrow and show us those points.
কাল আসতে পারবে তো?
হ্যাঁ, কাল আসবে।
খুলে রেখেছে ধরে
কত আমাদের আগে একটা টুপি হয়েছে
হ্যাঁ
There are two p.m. fixed matters. One is item 18, the other is item 20. Milord,
18, I am appearing for the
accept that. Milord, in item number 20, Milord, we were to come back that Rajiv Brahma matter. Milord, I have held, Milord, at least 7-8 sittings with the education secretary as well as, Milord, the commission's chairman. Milord, we are working out things. We will require some more time, Milord. We are trying to find out, Milord, where we can mix and match to yes.
But Mr. Dotto, don't take subsequently a point that it is not possible.
No, we are trying. That's right. That's why we are trying, Milord.
Then
give us, Milord, some time, Milord.
Who are there? Take a shorter time so that
আরো মুশকিল 500 গেল কোথায় এই তো সরি না ওর সাথে তো বসতে হচ্ছে 200 give us a fortnight's time, Milord.
আরেকটা নেই 29 তারিখে পড়বে
আমি আসছি 30 তারিখ
এই ফাইলটা একটু দাও ফাইলটা 18 কত আইটেম নাম্বার
20 না 20
Mr. Dotto, which
20 item 20
you are in that mission?
Yes, that
Yes.
is for the assist chairman. তো নোট করার
20 to 34 20 to 34 ও আচ্ছা
এখানে এটার জন্য নাকি
My lord has
okay on that day
my lord observe that will be decided later on.
yes
No, that the observation of the court.
No, that's last officer. Then I mentioned that our violation is different
Oh,
violation.
that right.
We have been kept outside the para in spite of laws.
Different violation, different council.
That's why we have taken
The different council.
তাহলে তো আমার 18-তে আর হবে না
হবে এত চিন্তা করছো কেন সব হবে
ও আচ্ছা আমরা কেটে করি
ওই মামলাটা যাতে হয় তার জন্যই তো ব্যবস্থা চলছে
না একটু বেশি
আর বেশি
তোমরা ব্যস্ত আছো না আদার্স সব জবে
হ্যাঁ ঠিক
পার্ট এন্ড পার্সেল বাবা বললে তো হবে না
উপর থেকে নিচে পার্কুলেট করে তো
কেউ বিশ্বাস করবে আচ্ছা আমি বলে দেখবো যে বিশ্বাস করে কিনা কোর্ট বিশ্বাস করে কিনা বলে দেখি হ্যাঁ যারা ওখানে গেছে তারাও কেউ অ্যাবনর্মাল নয়
নর্মালসিটা হারিয়ে ফেলে
কিছু করার নেই
তুমি তো এত দূরে ছিলে এখানে চলে এলে দেখো
মারবে বলে চলে এসেছে দূর থেকে মারতে পারছে না দূর থেকে মারতে পারছে না
ঝামেলা করলে কেউ কিচ্ছু দেয় না
Mr. Dotto, learned
I have one prayer, my lord.
learned.
Instead of 22nd, can it be on 30th?
No, 22nd, we are keeping it on 30th itself because 22nd.
My read by me.
Mr. Dotto learned, they are pursuant to our earlier order, comma, pursuant to our earlier order, the alleged contemners are present through video conferencing.
তুমি আছো এই পাচ্ছো সুবিধার মামলা তুমি আমি তো নেই
Alleged pursuant to our earlier order, the chairman of the commission, comma, the secretary chairman and secretary of the commission, the principal secretary of the school education department and the commissioner of school education are present through video conferencing. Mr. Dotto, learned senior advocate, appearing for the alleged contemners, submits that all steps are being taken towards full compliance of the order of this court, and he prays for Mr. Submits that
But I have held a
prays for an accommodation today. Learned advocate general bonus, senior advocate appearing for the alleged contemners are taking all necessary steps towards compliance of the order of this court. And he prays for some time. As the process is in progress. In view thereof, leaves the matter for further consideration on 30th April as fixed at 2 p.m. It would stop the personal appearance of the alleged contemners are dispensed with for the day, however, they would be present before this court through video conferencing on the returnable date.
I'm here from.
Order may be passed in the other matter.
Other matters are different, your losses.
Dr. Sarnal, we take it up on 30th.
But I tell you, losses, one thing. Even they come up today and say that in the matter, my learned advocate general appeared that they will comply with that. Still, our violation will remain. So that will not be solace to us.
Very good. We will.
Another point.
So, Mr. Sarnal, ultimately you want appointment, na? Ultimately,
we have already been excluded in spite of your lordship. We are not within the panel even. Though your lordship's direction will be considered as such.
Let the order be implemented in its totally in entirety.
Well, that's not the totality.
Then you will raise this issue.
Well, probably I could not communicate to your lordships. Whatever your lordships directed, 14,052, that should be in the panel and should be whosoever interview and counsel. But we have been kept out of that.
very good. So if today this 1241 and
So will not be.
you're right. You are right. If this adjustment is done, in that case, we will consider and we will say to adjust and give it to you. So for that, as a temporary period is there, if they start complying with this, a major stumbling block will be over. Now you are right that even if it is complied with, I do not come into the purview because my name is not there. My name is not there in respect of 14,000. They illegally excluded me.
Well, that's why what I'm praying your losses, let them take into consideration.
They have filed an opposition also, na? That is the problem. Then
in my matter, they have.
So we have to then dispose of the contempt, Mr. Sarnal. Try to understand.
That's a separate violation, your lordships.
Violation is punishment. If you want appropriate direction.
Violation, I'm not asking for punishment.
So naturally, what you are asking that I should be given appointment. We are dealing with the entire issue. If that compliance is done, Mr. Sarnal, it becomes easier for us to give a handle to them to take aid of that and appropriately adjust. Please, please. We are not running away. We will be there. On 30th রেখে দিও.
They have stated they have 5,000.
But item number 27, 28 and 29 are similar to my lord, the item 20, my lord. Same order may be
all are appearing on that day.
Similar.
30th at 2 p.m.
Yes. The similar order may be passed.
Order may be passed. Similar order.
We are not passing order. It will again go down. Let it be. Let the bunch be here.
As well. Grateful.
চলো কোনটাতে দিলাম
Yes, next 18.
For the applicant.
And I appear for the alleged contempt number 2.
I appear for the alleged contempt number 1.
The finance secretary.
And you will also kindly look into your last order dated 5th March 2026.
এনাদের ইয়েগুলো করে দিন, আইটেম নাম্বার 20 গুলো ইয়ে করে দিন। এনাদের আমাকে তো সেটা
Is what happened? Any development?
Kindly see your lordship last order dated 5th March 2026.
Yes, yes, we have seen that. Any development?
No, may I file an, I pay for the finance secretary.
So you not comply?
They said they will not comply by this affidavit, which was subbed upon me just 5 minutes back. They will not comply, they say.
No, I don't say they don't comply. I mean, don't put words in my mouth.
That is the
Please, let me place it, Milord. I think when I appear for alleged contempt, my mouth has to be the lowest. The only thing
So sometimes you raise your voice also.
not in contempt.
Oh.
Other times,
we are not intimidated.
other times is a different story, but in contempt, my voice is lowest. No,
Boss, there is a problem. Problem is this West Bengal State Legal Services Authorities is a party respondent in the appeal. That I passed the order, I have been appointed as the executive chairman of the State Legal Services Authority.
Well, this not related to
these are not issues.
not an issue.
These are not issues, Milord.
I have thought over the issue to avoid any sort of conflict of
Milord, I give up.
Mr. Banerjee, you can say so.
No, I say this way responsible.
Any sort of conflict of interest, I do not want.
There would not be any
But my
conflict of
brother
interest.
will be there. I will send it for assignment, and my brother will be there in the bench. The entire notice.
We are ready, my land. Senior feed is also
Mr. Ghosh, the situation does not remain as it is today. Today we are hearing a content.
No.
Suppose today, if I suppose,
No,
good, bad,
your lordship is
indifferent,
saying
I pass any order, then you know, nobody knows that who will go up to that before the Supreme Court. Those Justice Arun Mishra's judgment is clear. Unless and I think that it will be, but it is a contest. So please, I think I have thought over the issue. I have spoken with my brother also. So I think it will be better if the bench is constituted with my brother and you do the Ashok.
But no, I can say, your lordship can even record.
You will always. I do not expect any advocate will take a ground that, my lord, you do not be
No,
here.
but Milord, if I am not there tomorrow.
No, I know that.
That is also a fact. Milord.
It is my decision.
No, absolutely.
Records would reveal that the West Bengal State Legal Services Authority is a party respondent in the appeal. Stop. Subsequent to the order passed by this court on 5th March 2026, one of us, bole amar naam diye diyo, has been appointed as the executive chairman of the West Bengal State Legal Services Authority.
Are there.
The
finance secretary is there.
Pursuant to our earlier order.
No, finance secretary is there online.
Where is the finance secretary?
My lord, I am here, but my video has been switched off. I do not know why. Start my video. Yes, now I am starting my video. Yes, thank you, sir. Thank you.
I was told.
Pursuant to our earlier order.
Confidence I have.
And fear they have.
Playing hide and seek in the court.
Never.
Pursuant.
The judicial secretary and the finance secretary.
The principal secretary.
Finance
Department of Finance.
Department of
Additional Chief Secretary for ACS.
He's Finance Secretary now.
Yeah. Secretary Finance.
Acha, pursuant to our earlier order, the alleged contemners are present before this court through video conference. Their appearance dispensed with for the day.
Kindly noted their appearance and don't dispense with.
No.
Kindly noted their appearance and don't dispense with. For the day, kindly record that. Otherwise, it will be a.
May I say this? If your today your lordship dispenses
It is
it,
video conferencing, Mr. Banerjee.
yes.
Have a nice time before the next bench. They will be there video conference.
No. My humble submission, if your lordship dispenses the appearance in the next bench, again direct, we shall be obviously.
So you please take back your affidavit, file it on that day, share a copy with your friend.
No, we
I
will.
You have already got. Acha,
As I
what
said,
is
I
that?
never pay hide
What
and
is that, Mr. Banerjee? What is that? What
This is an affidavit
affidavit
on behalf of the Finance Secretary.
Huh?
No, your lordship has not given any direction.
Let the affidavit be placed with the.
Dispense with only for this date. Acha, let the matter be placed before the Honorable the Chief Justice for assignment. Yes.
Much of.
ওনাদের অ্যাপিয়ারেন্স গুলো দিয়ে দিন।
Next.
Why you are not doing, Mr. Banerjee?
I'll tell your lordship, my lord, it is just my lord, now that the matter, my lord, not today. This matter came up for consideration on 2nd May 2025. No, I'm sorry. This matter, sorry, on 26th November 2024, this e-file went to the Finance Secretary, Finance Department, where, my lord, the specific thing was the noteship that is there. My lord, your lordship,
Tell us this, why you are not complying?
because this entire appointment was permitted of this 200 odd people on the specific thing that under no circumstances in future they will never be regularized. That was the specific condition for their appointment. That is the reason.
So that reason has attained finality up to the Supreme Court. How will you come out of that snot?
No, pardon me.
When we heard
Your lordships have never directed that. Your lordships have only been
yes, no, I tell you, we said Mr. Tapan Mukherjee appeared. We recorded his submission.
That it is being
no.
Draft rules are being amended.
Believe everybody. The draft rules. He said that the principal secretary of the judicial department, as we have found from the records, he himself has sent it to the finance.
Yes.
A principal secretary can never act unless there is a direction to that effect, that this will be a policy decision of the state. Now, he has done it. Now in the time of filing the contempt, he was not taking a difference. He in fact could not take a different stand. He said that we need the concurrence of the finance. So I said that this concurrence will be worked out. Mr. Mukherjee was there. Give us some time, my lord, we shall do it. On this understanding, we dispose of the
absolutely. But I've seen that.
Now after that, this point was taken that it was not rooted to us, e-filing, etc., etc. So we said that we have to go with our order. You filed an SLP against that. Initially, our order was stayed. Subsequently, SLP has been dismissed. Your modification application, we have also dismissed.
Review or modification?
Recalling application.
Try
That was also appealed against.
Try to advise your client that there is no way out. There is no way out. At best, you can say that it is a policy decision. Let the elections be over. We will do it within such and such. That can be understood. But you just cannot take up and throw them off in the Ganges. Why the government is going to that extent also, we do not know. Anyway, I need not comment further because I have recused myself. But this conduct, Mr. Banerjee, kindly consider when you sit with your clients.
Sir, may I make a few submissions on it? Now we are not hearing them, but I know, my lord. It is my duty to answer to your lordship's query. Forget about the matter, forget about it, the order, everything, forget it. Your lordship is disturbed by this fact. But my lord, my humble submission is, my lord, today the entire proceedings up to the stage of the appellate court and even filing of thing was handled by the judicial department. Now, my lord, if your lordship sees the observation in the file, I can show you lordship because there's nothing hide and seek. The entire issue cropped up is the last time when the appointments were made, it went up with the appointments were made with the approval of the finance department. So, my lord, when this rules were being sought to be amended, Lord, at that juncture, was it not appropriate also that the approval of the finance department be sought for? What the entire confusion has happened, if I may use the word, your lordship should not take me amiss. Confusion because judicial department did not take before carrying out the amendment to the rules. They did not take into consideration the approval of the finance department because ultimately the money has to come from the finance department. So they ought to have forwarded the e-file, send it to them. If they would have approved, then carried out the amendment of the rules. But without doing that, they themselves carried out these started preparation of the rules.
That is a wing of the government, Mr. Banerjee.
Yes, but the thing is that now finance.
So it is a dispute inter se the department. Now.
Yes. Yes, absolutely.
The finance says that I will not do what you have suggested, and the judicial says that I have done what is needful.
Lord, if your lordship
unless this action of the principal secretary of judicial department is struck off from the records, you do not get a window. It is a settled proposition, good, bad, indifferent. State cannot say two words.
The judicial department does not have any financial capabilities.
Oh, you deny judicial department not to be a department of your state?
The financial capability, they should have sought the approval of the finance.
So that is your explanation, Mister. You are giving. You are acting a bit. I think it is a question of. I need not comment. It seems from the papers, Mr.
But I'll tell you, lordship, very candidly. Again, I'm saying I have to come clean before your lordship. I care more about than any other matter.
Now, on the basis of this argument, Mr. Banerjee, can you come out of this impasse? We can understand there is an impasse. There is a huge financial implication. Their induction was knowingly made against temporary posts. We understand everything. But when a decision the state says, now the finance cannot say, subject to what you argue, that I don't have the money, sir.
I don't the allocation of this money. 38 people regularized in the government position.
That is exactly, but in content, Mr. Banerjee, after the remedy up to Supreme Court has ended, think of something else.
Greatest of respect, my lord. Your lordships, fortunately for me, I say the word fortunately, have never directed anything.
You have
never directed that these be regularized. If your lordship had said, I'd be absolutely.
No, that was argued before Supreme Court. No. Supreme Court, it was argued that judicial department has done this in its own way. I am
not aware.
It was stayed. Our order was stayed. What was our order?
Your lordship only said
only
direction.
Direction that in view of such statement made, we do not want to proceed further. This direction was stayed, Mr. Banerjee. Why stayed? Because there was a dispute that, judicial secretary has done this without the concurrence of the finance. This responsibility of money will be there. All right, we shall look into it. Matter stayed. Then it was hard out. It was dismissed.
With greatest of respect, I do think, my lord, India's Supreme Court has got into the merit of the matter.
Maybe accepted your plea, suppose. gone into the, then you have to do something.
Then all it does is your lordship's orders remains. I am not in comms with the fact that your lordship.
So in spite of our order, you will not comply.
No, your lordship's order is never to grant.
This what argument you are advocating? Anyway, I am not in the recuse myself.
Again, I said, I am over here, my lord, to address your lordship. To me, as your lordship is hearing it.
They are litigants. It is the state. You are the supreme authority. You cannot set up any rigmarole that the finance will say, oh, the law has done, I will not do it. It is becoming an ego problem then. Then it has to be remedied.
Lord, with greatest respect, today, financial implication when it is involved, anything, my lord, for that, any issue of finances comes in, Lord, always the prior approval of the finance is taken.
Argue that before the Supreme Court and save yourself. Save yourself, Mr. Banerjee.
I will, my lord.
Today, if they are allowed to go scot-free in this situation, then the entire judicial system collapses.
But
State
on the other hand,
government,
where does the budgetary allocation come for this payment?
thousands of cases have happened. Organizer teachers, you know, you are victims of that.
That is one thing is, my lord, if your lordships had directed.
Anyway, I need not go into this. I have recused myself. But when you are a sensible person, you are appearing. You have appeared in many matters before this court. You have appeared in plenty of matters. You do not unjustly oppose a particular claim. That is what we have seen as you had claimed.
No, obviously.
So it is, unless the council concerns gives this thought to the officers, they are administrative officers. The way you feel, they won't be feeling it in that manner. It is not possible also. It's an administrative officer, concurrence, sir. How I will give the fund? No concurrence. Where will the budget come from? No allocation of budget. What will we do? These are administrative functions.
Will follow in other departments also.
No. That it will not be treated as a precedent. That can. Do you remember that matter? Organizing teachers also same.
Your lordship was in the bar in those days when your lordship.
Justice.
I think 100 of them.
Justice Dilip Sheth, his lordship then was. Justice Mr. Shaktinath Mukherjee. Unnecessarily the officers to be present before us, but it is going beyond bounds and control, going beyond. So we would say to you, as you are appearing, I may not be there, but you would be there. I would ask you, my brother would be there, that Mr. Banerjee, do something. We don't not unnecessarily in contempt what punishment.
No, that is not. We don't look at that as
punishment.
I can understand what your lordship is feeling. That will not. I try to communicate. Will not. I think that they're all
not communication, Mr. Banerjee. You have to sit with them in a conference and explain to them the pros and cons. Some solution must come out. Otherwise, some solution at least. All right, there are various ways of compliance of court order. Allocation of money is there, policy decision is there. Think over something, but the persons who are standing with a thought at the instance of the government that I am being regularized. Today, if you take away that right, Mr. Banerjee, maybe. Anyway, you are there.
My lord, can I make a humble submission, a small 1 minute, my lord?
No, Mr. Secretary, I won't be hearing the matter. So on the next day, when the new in my place and street, somebody else would be there. And my brother.
My lord, I just wanted to bring it to your kind notice that ultimately, my lord, the amendment of this recruitment rules, final authority is not even finance department, my lord. It is the cabinet. So cabinet approval will be required, my lord. Just for your kind this thing, my lord. So it will go to cabinet.
And you should have told the Supreme Court. Now the water has gone through the lines. If you would have pointed out to the Supreme Court, we could have understood. Then Supreme Court must have come with a way out. You are saying I am not standing in the way. It is a question or decision of the cabinet. But these persons cannot go to the cabinet and make a representation. You allow my plea in these circumstances. It is for you, responsible officers like you, to do the needful. Yeah, give a thought to it, Mr. The Finance, you are in control of that. The problem should be resolved in some way or the other. Courts do not want officers to be unnecessarily present. As such, we directed video conferencing appears. Otherwise, we could have issued a rule of contempt. We usually restrict ourselves. Because you are also holding responsible posts, you also take policy decisions. We understand the pressures which are upon you also. Unnecessarily, we do not call. That is why I was requesting Mr. Banerjee to sit with you and see as to what can be done and how the impasse can be resolved. Yes, call the next matter.
On the next. না 19টা একটা 19 আছে না হ্যাঁ ও
এবার বলবে ফিনান্স করবি ক্যাবিনেট
But I appear for the respondent Madrasa Service Commission.
But the impugned order is at page 116 of the application.
Any private respondent? Any private?
No, there is no private.
Who has intervened?
But the two similarly situated, claiming to be the similarly situated candidates like the appellant, has filed application for intervention.
Who is appearing for
that? Mr. Shamim Ahmed in one of the matters, one of the and Mr. Khoirul Alam is appearing in Can 2.
Order impugned is 19th March.
My lord, 19th March 2025.
Any interim order we passed?
No. It is ready for hearing, my lord. The appeal was ready for hearing, my lord. The affidavits are
file your paper books then.
But that pursuant to the order passed by the Honorable Coordinate Bench, my lord, we have used, my lord, the combined written notes of argument where we have annexed all the documents, my lord.
A paper book may not be required because it is, I agree with my learned friend, on one point. There is no single other point.
Yes, please then.
Yes.
That's a delay point.
Page 116, my lord.
Yes.
Matter, may I read for your lordship, my lord? Matter relates to selection process, namely 6 state level selection test conducted by the West Bengal Madrasa Service Commission for appointment of assistant teachers in Madrasa. It has been contended on behalf of the petitioner that petitioner has participated in the aforesaid selection process with teacher training qualification, but in spite of possessing qualification, he was not given preference while giving appointment. In support of such contention, reliance is
What
placed.
is the preference, Mr.
But as per the recruitment rules, my lord, if a candidate having the desirable qualification, that is the training qualification, he will be given appointment. He will be given preference in while giving appointment against the candidate who doesn't have that qualification. And if both the candidates pass the written test, my lord, in that case, my lord, the candidate having the desirable qualification will be given preference.
So what is the process of selection? First written test.
Written test.
First written test, then verification.
Then the interview.
First written test, then interview.
Yes, my lord. Personally tested.
Yes, then continue.
Yes, ma'am. In support of such contention, Reliance is placed on order of a coordinate bench dated 14 June 2022, passed on a writ petition such and such. It is submitted on behalf of the petitioner that since Akmal Hossain's the concerned authority of West Bengal Madrasa Service Commission was directed to give preference to the petitioner in that writ petition. Since they were having the teacher training qualification, petitioner in the present case is entitled to get the same treatment in the matter of appointment in the post of assistant teacher in connection with 6th state level selection test 2013. Rana advocate representing the West Bengal Madrasa Service Commission submits that aforesaid selection process was complete long back. A panel was prepared on concluding the selection process on 13 June 2018 and panel expired on 13 June 2019, whereas the present writ petition was filed on 3rd January 2024. According to the Commission, the present writ petition is not maintainable since the same was filed much after the expiry of panel. Having considered the submission made on behalf of the parties and taking note of the materials available on record, it transpires that though petitioner appeared in 6th state level selection test 2013, but he approached the court in the present case on 3rd January 2024, which is approximately 5 years after expiry of panel. Panel prepared in connection with the aforesaid selection process expired on 30th June 2019, though reliance is placed on the order passed on Akmal Hossain, but the petitioner is not entitled to get benefit of the ratio of Akmal Hossain since that the writ petition was filed on 14 June 2019, that is prior to expiry of panel. In the present case, it appears that petitioner is fence sitter. He filed the writ petition 5 years after expiry of panel. It is straight law that after expiry of panel, candidate loses right to agitate his grievance in connection with a particular selection process, and passed by the Honorable Supreme Court. On that ground, my lord, the writ petition was dismissed. But my contention is that in 2018, my lord, the petitioner filed a writ application seeking appointment in connection with the selection process, and that was disposed of.
2018.
Yes, my lord. Which is appearing at page 108 of the application.
Page 108,
my lord.
Tell us what has happened in that.
Yes, my lord. In that matter, my lord, we have prayed, my lord, the seeking.
Let us go back to page 100.
Yes, my lord.
Same petitioners.
There are several petitioners. One of the petitioner was the petition number, my lord.
Soumendu Chattopadhyay.
Soumendu Chattopadhyay was also the petitioner in that petition.
In that page 108.
Yes, my lord. 108.
Yes, what you want to show?
My lord, page 108, my lord. Prayer is, my lord, that has been quoted, my lord. Prayer B, a writ in the nature of mandamus, directing the respondent commission to fill up all vacancies which have cropped up till 5th September 2016, so that the petitioner are rightly appointed as assistant teacher. That writ petition was ultimately disposed of by directing the chairman of the commission to consider and dispose of the representation of the writ petitioners.
So your only ground was
that I did not prefer
Akmal and I am similar. Now Akmal was given appointment since he approached the court prior to expiry of the panel. Now Akmal and your marks are similar.
But the Akmal and the appellants, the desirable, we both are having the desirable qualification.
Very good. But was your mark same as Akmal?
But
because you started arguing that desirable means if both of them obtain equal marks in written test, then preference will be given to the trained candidate.
Yes, madam.
So you show us that Akmal has obtained more marks than you or less marks than you. Now, what did the chairman do after this?
But the chairman passed a recent order, my lord.
Page?
That is part of their reply, my lord, in opposition.
Yeah, they did not communicate any order.
Yes, my lord, that was communicated, but it is not part.
It was not. No, you have filed a supplementary affidavit.
Yes, my lord. Before the honorable single bench, my lord, disclosing that we filed writ petition within the lifetime of the panel. Since the writ petition was dismissed on the ground that I did not prefer writ petition within the lifetime of the panel.
You didn't prefer within lifetime of panel.
Yes, my lord. This writ petition was
Yeah, that earlier it was.
Yes. On that.
So where is the order of the chairman?
Chairman, yes.
Affidavit in opposition, which page?
Page 7, my opposition. Page 7.
Page?
7. Page 7 of the opposition by commission. Recent order. Sixth of December 19.
But this order, I am relying upon the order passed by the honorable
Not challenge.
single judge in that Kaji Shahbaz Ahmed, that is where the writ petitioner appellant was one of the parties. On the ground, my lord, the petitioner already, my lord, the filed a writ petition within the lifetime of the panel.
We understand.
Yes, ma'am.
We understand that. Is that your only ground?
No, my lord,
Suppose the writ petition would have been allowed.
Yes.
Then can you show us that you secured more marks than persons who have been appointed availing preference for the training qualification?
My lord, the respondents, my lord, have.
Achha, let us read the order of the chairman, what he has said.
Here below.
Yes.
My lord, may I place the order passed by the my lord Justice Gangopadhyay, as his lordship then was in Akmal Hossain, my lord, which I am relying upon.
No, please answer. Kindly come to page 8.
8 of the opposition.
First, second, third, fourth, fifth paragraph. Although
most of the petitioners were called for personality tests in accordance with rules of the commission, but they were below ranking of empaneled and waitlisted candidates in the final merit list. But this point was taken up to the Honorable Supreme Court by the commission, my lord. That SLP was dismissed. Now, my lord, they cannot take this point in the before this Honorable Court, my lord.
What point they can?
But they have taken that a candidate, if he does not come within the merit, he will not get preference in terms of the, despite having the desirable qualification. That was agitated before the, up to the Honorable Supreme Court also, in their SLP, my lord. That point was not considered and SLP was
So
dismissed.
you show a single instance
Yes, my lord.
that person who has secured lesser marks have been
My
given
lord, Akmal Hossain, my lord, itself, my lord, all the candidates were who are granted, my lord, the appointment pursuant to the order of this honorable court. They all the petitioners were my lord, the secured, my lord, lesser marks than the, my lord, the last cut-off marks, my lord. Despite that, my lord, my lord, the
So what is their reply to that?
but they have taken the point that
They have admitted that you secured
lesser
one-
marks.
lesser
marks?
lesser marks.
I
think I'm not being able to. I'm saying you all appeared, I appeared.
Yes.
Written test.
Yes, ma'am.
You got 20. Did I get 20 also?
But our case is, my lord, that the candidates without having the desirable qualification have been granted appointment.
Oh, that is.
All right, you proceed. Show us what more you have to show.
Desirable qualification and essential qualification difference.
Yes.
And you are seeking preference. When preference is given, when there shall be two candidates having same marks,
but
then he can claim that for having any qualification, give me preference.
But it is
over the other.
But the
Should be subject to correction. Now you clarify this point.
My lord, may I place, my lord, the page 109 of the written notes, our written notes, my lord, where we have annexed the.
Where is your written?
But I have already, my lord, submitted before, my lord.
The only thing, if my learned friend relies on written note, then a copy should
It is part.
Have you not given the copy?
It is part of their the opposition, which was filed in connection with the
If
Akmal.
he refers opposition, I don't need. But if he
Yes.
refers written note, I don't
Part,
have.
I am referring the part of the opposition.
Towards the opposition.
Yes, my lord. Opposition, my lord, not opposition in this matter, my lord. The opposition which was filed by the commission in connection with Akmal Hossain, my lord.
So that he has to get.
But I have already, my lord, circulated, my lord.
কোনটা রেফার করছি বল?
ওই যেটা অপোজিশনটা দিয়েছে।
ও
হ্যাঁ।
ওকে।
এই জাসি সেনের কোটা করি। ঠিক আছে, ঠিক আছে।
You have to bring the same on record.
But it is part of the supplementary affidavit
এতক্ষণ
also.
শুনে টুনে এখন নিয়ে করছে।
Supplementary affidavit.
এটা দাওনি।
I already served, my lord. It is part also part of the supplementary affidavit also. Let kindly see, my lord.
That
Of this read affidavit.
I remember that he supplied me with the supplementary affidavit because he said I'm referring written note. I thought it is a separate document. If it is a supplementary affidavit, definitely I'm having it. So let him argue.
Supplementary affidavit আমাদের
Written note যা কপি দিয়েছে তার থেকে supplementary I have no problem.
Page 19, my lord.
এই যে
But page 19 of the supplementary.
Let my brother get.
combined with written notes. Application for
আমার এখানে কিছু নেই তো আবার।
আপনার এখানে এই যে got it. Yes, supplementary affidavit.
Yes, ma'am.
Yes.
Page 19, my lord.
Yes.
Page 19, my lord. Akmal Hossain, my lord, they are reply under RTI. But they have replied that your mark in history is 64.87. Height, weight, marks of the impanel candidate in the above subject category in the Bengali medium is 84.37. Lowest weighted candidates of the impanel candidate in the above subject category in Bengali medium is 66.31. And the lowest weight candidates of the wait listed candidate in Bengali medium general category is 65.50. Therefore, my lord, admittedly, my lord, that Akmal Hossain has obtained, my lord, the lesser marks than the last impanel candidates.
Lesser marks than the last.
Yes, my lord. But the Akmal Hossain has obtained, my lord, 64.87.
Very good.
Next page, my lord, Tohadish Ali. Tohadish Ali.
Now you read the clause 5. Answer number.
Desirable, yes, my lord. As desirable degree was, as B.Ed degree was desirable qualification in honors PG category of 6 SLST 2013, there is no such category of 10 and
10 and unten. Okay.
Next page, my lord. Tohadish Ali. He was also the writ petitioner in Akmal Hossain matter.
Yes.
But he also secured, my lord, 65 marks and obtained, my lord, the could not come within the zone of consideration as per the commission, my lord.
No.
And all those
Bengali medium general category. Bengali medium general category. Akmal was also in Bengali medium general category.
History. All are history.
History.
Then it will be Bengali medium general category in the subject of history. Yes.
Next, my lord, the Tohadish Ali. Your marks in
why didn't you show this to the single judge?
But it was a part of the supplementary affidavit, but the honorable
You have not placed. Unnecessarily appeal has
but
come.
the honorable single judge did not even consider the supplementary affidavit. It was it was filed on the date of hearing, my lord, but it was not even considered.
So what were you doing? You will not tell the honorable judge that please come to this page.
Which number you have secured?
No.
How much did you secure?
But I have obtained, my lord, as per the opposition, my lord, their opposition, I have secured, my lord, 63.83 marks, whereas 63.83 marks.
63.83.
That is above the cutoff.
No.
Below the last, but the last
Then
selected
below
candidate,
the last
66.31.
60. Yeah.
But the page 4 of their opposition.
Now your only case you showing.
You got how much?
But I have obtained, my lord, 63.83 marks.
83.
My lord.
Where do we find?
But at the page 4 of the opposition filed by the commission in connection with this appeal.
একবার opposition যায় একবার supplementary যায়. Page 4 of the opposition.
My lord, paragraph 9.
Para 9. ঠিক আছে. So you secured lesser marks than the last
cutoff
impanel candidate.
last impanel candidate.
Last listed candidate.
Yes, madam.
Lowest weighted marks.
Last selected candidate.
Weighted marks, not weight listed marks.
It last
Lowest weighted marks.
Weight marks of weight listed candidate.
আচ্ছা আচ্ছা
weight listed candidate হচ্ছে 5.5. You got 63.83. So your case lies that Akmal, although secured 64 such and such, and he was given appointment, but you have been
since the Akmal Hossain was having the B.Ed qualification, my lord, this honorable court has held that the candidate having the B.Ed qualification has to be given appointment over the candidates who do not possess that qualification. That order has been upheld up to the honorable Supreme Court. And in the honorable Supreme Court, my lord, in the SLP, my lord, the commission has taken the point that unless the petitioner come within the zone of consideration, not the mayor possessing the B.Ed qualification will not the entitle them for getting appointment. That SLP was dismissed. Therefore, my lord, the commission, my lord, cannot re-agitate those points before this honorable court.
This is your only point.
Yes, my lord. And
let's hear him.
And my lord, it is settled law, my lord. Even if a candidate doesn't, my lord, approach this honorable court, if any order is passed.
No, you approached. Here you approached. That was not taken into consideration by the judge.
And I will be relying upon one decision of the honorable Supreme Court, where the honorable Supreme Court has held that if one decision is there, my lord,
similar benefit is to be
even if
provided that.
No,
there is a proviso in that judgment.
But unless it is specifically held that judgment is judgment in personam and it is restricted only to the petitioners. It is also part of my written note, my lord.
Page. Supplementary affidavit.
No, my lord, the
written
page 116 of my written notes.
written notes এ
Written notes. Written notes তো আমার কাছে
written notes you have not served Mr. Dhar and how we can look into
written note you have not served.
no
No, where is that? You have annexed it
Yes,
here.
my lord. It is
Page
page 116, my lord.
of the stay application.
No, my lord, the
Written notes. We don't have the written notes.
copy তো দেয়া আছে।
আমাদের কাছে কোথায়?
এইটা একটা দিয়েছে কি written combined written notes of
Combined written notes.
ও আচ্ছা।
এটা বেরিয়ে দিয়েছে জাস্ট জাজমেন্টটাই দেখিনি
This is page 116.
Yes, my lord.
Judgment.
Judgment.
The similarly situated candidates have to be.
Yes, my lord. Even if they do not approach the court, the authorities are under obligation to extend the benefit which has been granted by the honorable court, unless there is a the rider. Paragraph 16, there is a rider.
পরে পরে বললো provided that they will not be fence sitter.
No, fence sitter.
No, the main judgment 2015. Whether
But it is a-
2015 was considered in that judgment.
It is 2025 judgment, my lord. The-
Provided that they shall not be fence sitter.
But it is a judgment of
Similar
2025, my lord.
benefits shall be extended to the similar situated candidate. It is well settled. But subject to the condition, they would not be fence sitter.
Paragraph, which paragraph?
My paragraph 14, 15, 16, and 17. May I read for lordship, my lord?
Yes.
It is settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his or her favor, others similarly situated ought to be extended the benefit without the need for them to go to court.
To court.
Yes.
Yes.
Paragraph 15, my lord, K.I. Shepard was considered.
আবার এটাই ব্যাক করলো কিন্তু আচ্ছা ঠিক আছে 25-এ
Then, my lord, the paragraph 16, my lord. No doubt in exceptional cases where the court has expressly prohibited the extension of benefit to those who have not approached the court till then, or in cases where a grievance in personam is redressed, the matter may acquire a different dimension, and the department may be justified in denying the relief to an individual who claims the extension of the benefit of the said judgment. Here, my lord, in Akmal Hossain, my lord, this honorable court never, my lord, restricted the respondents to extend this benefit to other similarly situated candidates.
ঘুরিয়ে বলে দিল নাকি
Very good.
And may I place that judgment passed by the Akmal Hossain, my lord? Page 60 of the stay application, my lord.
Page 60.
My lord.
This was not appealed against.
Yes, my lord,
complied
up to
with.
Supreme Court, my lord.
Oh, acha.
My lord, may I read for lordship, my lord? But the petitioner case is that though they have desirable qualification, that is B.Ed, etc., they have not been given recommendation for being appointed in Madras as assistant teachers against the recruitment procedure of 2013-14, for which advertisement was issued on 6th February 2014. Under proviso to Rule 3 of the recruitment rules, namely West Bengal Madrasa Service Commission recruitment, selection and recommendation of persons for appointment and transfer to the post of teacher and non-teaching staff rules 2010, all the persons who have desirable qualification, if qualified in written examination shall get preference over the candidate who has qualified in written examination but has no desirable qualification. The petitioner pinpoint their case here by saying that they have not been given preference by Madrasa Service Commission. I have heard the commission, but there is no cogent reply as to why the petitioner were not given preference. The petitioner have indicated that untrained candidates, that is, candidates who do not have the desirable qualification, have been given appointment for the post of teachers, but they having desirable qualifications have not been given recommendation for appointment. I direct the commission to give preference to the petitioners over the candidates who do not have desirable qualification and recommend the names of the petitioner in the post.
Very good. Where is the Supreme Court order?
But page 114, Mala. And passed by, may I place the order passed by the Honorable Division Bench?
Oh, it against it.
But page 64 is the order passed. The commission preferred writ appeal before against this order, Mala. That appeal was also dismissed. Page 64.
Women different.
Page 64 is the order passed by the Honorable.
Ignoring the very
আরে আগে ডিভিশন হয়েছিল
Oh, division bench 64, Malat. Page 64. May I read for lordship?
ইটস লাইক আ পিলার দুটো এল আছে একটা কেটে দিলে আর সো সিঙ্গেল বেজ ডিভিশন দিস
But the page 64 is the order passed by the Honorable Division Bench. May I read for lordship?
You have to root Mr. Dhar. Catch hold of him.
May I read for lordship? Malat? We have heard the learned counsel of the for the appellants. We are convinced from the record that the learned single judge was justified in allowing the claim of the petitioner as they have desirable qualification and they should have been given preference over the candidate who do not have the desirable qualification. The candidates appointed are admittedly untrained. We also could not receive any satisfactory reply from the appellants for exclusion of the writ petitioner in not giving them preference. Under such circumstances, we do not find any reason to interfere with the order passed by the learned single judge on 14 June 2022. However, we extend the time to comply with the order passed by Justice Vijit
Is
Gangapal.
that they went up to Supreme Court?
Yes, Malad. Page 114, Malad.
114.
Yes, Malad.
SLP dismissed.
Yes, Malad. But only one thing, Malad, I would like to Malad, to point out, Malad, that
After hearing the counsel,
yes,
we see no reason to interfere.
But
It's not SLP dismissed. So heard the counsel.
But in SLP, Malad, may I point out, Malad, they have taken the point that the merit should be given preference.
Where is that page? ওটা আবার কি?
SLP, copy of the SLP. But the grounds, Malad.
You should have brought that.
Only one.
SLP তে ground. Which paragraph?
But third, second, Malad, in the Backdrop.
Complaint appointed more than other impact of the removal of appointed on the basis of merit. And that will not be ওই রাইডারটার রয়ে গেছে না ওবিসিতে
ইস্যুটাই
এটা তুমি বলছো
question the correctness of the judgment of the honorable single judge. I cannot.
No, Mr. Dhar, we will send it back on remand. We will say that on this analogy, the writ petition could not have been.
No, I'm only on delay point. That's what I'm saying. That the judgment of the learned single judge holding that after 5 years he has, that is correct factually. That's the reason I said very.
So you first argue on
that, right.
If we hold against you,
correct,
then we have to remand it.
Correct. Fair enough. Fair enough. If I fail on that, naturally the lordships need not go into that. Lordships can send, because that was never touched upon.
Another window will be
Right,
open.
right.
So you please satisfy
Right,
us.
right. So, my lord, lordship has seen the 20th June 2019 panel expired. This is the admitted date. No question on that. Now, my learned friend is saying that along with some others, they filed a writ petition.
Panel is 30th June.
It's
30th June 2000.
I recorded 21st June. It doesn't make much difference. So June 29. June.
According to you, it is 21st June.
My lord, because the panel was published from 22nd June 2018, under the rule it is 1 year. So from the date of publication, 1 year it ends, and it's supposed to be 21st June 20. So that couple of days. So June 29.
30th June, the court observed.
I think that's a small difference, need not be, because the publication was on 22nd June, previous year. So I say that writ petition should be dismissed on the sole ground that he filed the writ petitions after 4-5 years. That's why I say that the learned single judge was right, because the first pillar of my learned friend's argument is, along with some others, he filed a writ petition. I have 2 points to say against it. Point number 1, that writ petition had got nothing to do with this preference point, number 1. Point number 2, that writ petition was sent back for decision to be taken. And decision was taken in December 19. So Lordship may even give him the benefit of December 19.
No, it may be not on preference, as you have argued.
It
that
is on completely different.
Completely different, but it is pertaining to the same selection process.
That's why I say I want to give benefit. That's why I say give him the entire benefit. So he gets the reasoned order is 6th of December 19. He filed the writ petition in June 2024. But that date is possibly enough.
That point you did not take in the writ petition.
Yes, that point, that was the.
That point was taken. Answer was that I will not consider your case at the threshold because you did not come prior to expiry of penalty. After that finding, your reasoning comes that see that they are not equal. It is not a question of preference.
Can you look at this way?
You are telling us that don't look at that aspect, but see, even assuming 2019 order pass, he ought to have been diligent enough to come immediately.
Yes, I say. Can you look at this way, my lord?
So this is your argument.
Yes, my argument is this. I could have understood that reasoned order is December 19.
He comes at
He comes.
20.
I could have understood. Now he's coming in 24.
He expired. He appeared after expiry, whereas HON'BLE appeared before expiry, and he appeared after 5 years from the date of penalty.
He এখানে হচ্ছে যে ও ওদের সাথে জয়েন করে এই ডিসপিউটটাই রেজ করেছিল, সেইটা ডিসপোজ অফ করলে করে চেয়ারম্যান সেটা ডিসপোজ অফ। চেয়ারম্যানের অর্ডারটা পাস হলো 2019-এ।
সেইটা কবে চ্যালেঞ্জ
সেটাই তো এই
চ্যালেঞ্জ দেখতে চাই।
Well, that order was on August 19.
That has not been challenged.
That has not been
So
challenged.
it is a continuing cause of action. It cannot be stated.
Well, the what
না, ও কিন্তু এই যে ও যে রিপিটিশনটা ফাইল করলো, yes, subsequent petition what you have filed, number of which is
that is
243 of 2024.
Yes.
So Mr. Bose, why didn't you challenge the chairman's order?
Yes, that's my point. That answer was about to come from your lordships. Then he took your lordships to the SLP side because that's a different thing altogether. Waiting period, but there are 6 direct judgments.
Closed and shut.
Chairman's order.
Yes.
Chairman's order.
2020.
Supreme Court disposed of the matter when?
Well, at the 20.
This is the textbook
16
case of
December 2020.
Pensita.
No, give us Justice Gangopadhyay's order date.
But at the 14 June 2022.
Justice Gangopadhyay's
Yes.
2022.
Yes. For the people who filed writ petition questioning on that point in 19 prior to expiry.
Acha, and when was the division bench order?
6 September 2023.
September 23. And Supreme Court is 16th December 24. So
Beautiful.
24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. 24. And in fact, what was never brought anywhere, in case the merit comes, I would say there is a division bench judgment of our court dealing with the identical rule specifically.
we are not on
and
that.
not merit, that's why I'm not saying. And Lordship, in my note, the first very judgment, kindly have a look at this 2010 judgment, the first one. What my learned friend today is seeking, because that entire selection is over, people are working there. This paragraph 60, I have my lord, just quoted 16, 24 and 25. So no relief after he approaches. If it is couple of months, I can understand. Well, a number of years. And seeing what happens.
But in case of Akmal Hussain, my lord, appointment has been given in 2025, my lord.
Akmal, we have to give because we are an authority. We are supposed to obey the court's order. That's a judgment in personam. We have to. This is whether it's a point of law to be decided for everyone. That was because if I read Akmal's judgment, I will show your lordships. It was restricted to the petitioner. Vis-a-vis, there is another division bench judgment clearly holding what lordship has said.
Mr. Thor, this issue which you are urging, that he had been a French sitter, you're
Yes.
right. But that also the court did not go into. Court said,
I understand.
Court said
After
panel
ex-
19
after
5
yes,
years.
yes, true.
So court has not applied the mind on the argument which you are advancing. before us.
Lordships kindly apply that part. It's a I would say it's a lack of articulation. Lordships can only on that score because it doesn't make much difference. Court should have ideally also taken into considerations reasoned order and then that 4 years. Court straightway said, I understand, my lord. Sometimes it's number of matters. Having seen 5 years,
French sitter is attributable to filing of the writ petition after 5 years from expiry of it.
This judgment was judgment in rem. But judgment passed by the Honorable.
No, you will not explain that what did you do for 5 years. This order of the chairman, this had sealed your fate.
Yes, but not.
This had sealed your fate. That 3183 vacancies, 8 subjects.
But
most of the petitioners personally details, but they were even below the ranking of empaneled and in the final meeting, for which their names did not appear either in the listener. So this finding was in 2019.
Yes, my lord.
When the issue was pending before the Supreme Court. Yes,
but the Honorable
2019, Justice Abhijit
But it was-
Gangopadhyay passed the order on 14th of June 2022. Then also you did not come.
yes.
My lord,
Now your argument is, I will not explain my delay. I will say that when was the point settled?
But
You're
in
saying
2022.
subsequently 2022 it was done. Then what prevented you from coming in 2022?
But 2022, my lord, in 2019, my lord, we have prayed for appointment, my lord. The writ petition was filed in 2018, which was disposed of in 2019. Thereafter, my lord, in 2022, the Honorable Court.
No, 2019, the order passed in compliance of the court.
Compliance of that.
Now from 19, that date of the order, we understand you waited till 2022. 3 years. Abhijit Gangopadhyay, his lordship passed the order. But in his lordship's order also, this lordship's order was a stray matter, which ultimately went and earned success.
But
your Justice Gangopadhyay's matter was not a matter in which the administrative authority pursuant to an earlier order of the court has passed an order.
But kindly appreciate one thing, my lord. The Honorable Court directed that, laid down the law that the candidate having the B.Ed qualification has to be given preference in the recruitment process over the candidate who doesn't have the desirable qualification. But we are under the impression that the respondent authorities, but extend the benefit passed by this Honorable Court to the other similarly situated candidate also, my lord. Since which I have relied upon the.
So give us the example that any person has been given appointment.
Not even a single one. We can't.
I have relied.
Try to explain.
Please
come to page 64.
But
a late entrant and a defaulter as
late entry defaulter and defaulter.
In the case of late entrants.
No, that is in sync. That is in sync.
প্রথমে হলুদ কার্ড দেখাই তারপর লাল কার্ড দেখাবো This is dated 6th of September 2023.
Yes.
We are convinced from the record that the learned single judge was justified in allowing the claim of the petitioners as they have desirable qualification and they should have been given preference over the candidates who do not have desirable qualification. Stop. The candidates appointed are admittedly untrained. That's a finding from record. Now, we also could not receive any satisfactory reply from the appellants for exclusion of the writ petitioners in not giving them preference. Under such circumstances, we do not find any reason to interfere with the order. However, we extend the time to comply. Now, what was the circumstances which had prompted the Honorable Division Bench to make this observation? Untrained have been appointed. This was applying all across in respect of the same selection process. Please come to page 61. Paragraph 2 at page 61. I have heard the commission, but there is no cogent reply as to why the petitioners were not given preference. Stop.
Petitioners.
The petitioners have indicated that untrained candidates, that is, candidates who do not have desirable qualification, have been given appointment for the post of teachers. I segregate this latter half into two parts. But they having desirable qualifications have not been given recommendation for appointment. Please read the first part of this sentence with page 64. Second paragraph of page 64.
Also, kindly see the directions. Directions was never for all candidates. There is no vacancy.
They will never tell you. Death then.
No, I have.
They tell you.
Well, that They are quite, I would say,
Now, Mr.
fair.
Majumdar, matter has not been hard on merits. Today, if you can satisfy us that you had not been a fence sitter, then we can set aside the order and remand it back to the single judge. But Mr. Dhor's argument, I don't know when you entered.
He's arguing that I have not challenged the 2019 order before 2014. I have not. That's why there is a delay of 5 years. No, rather 4 years. December 2020.
So what is your answer to that?
2019 December the order was passed. The rejection. Now, the judgment before the Honorable Division Bench was delivered in 2020.
No, 2023.
2022.
23.
No, 22.
22
তারপরেও file
Gangopathyay's order.
Yes, 2023.
ডিভিশন বেঞ্চের পরেও ফাইল করে
2019 is the rejection order. But
3 years.
apropos the writ petition filed in 2018 claiming for appointment.
ফার্স্ট রিট পিটিশন
First writ petition. But I prayed for appointment.
অ্যাপয়েন্টমেন্ট
Now,
then it was এটা ultimately chairman or commissioner says
the order was remanded to the commission for consideration of the representation.
commission says you secure
Simple
lesser
remand.
mark.
The court has not gone into merits. Rejection is no vacancy in 2019.
Rejection is
No vacancy.
2019, no vacancy exists.
No, you got lower marks than the
appointed
candidate or last temperate
But
candidate.
the entire principle was decided in Akmal Hossain's case, not where also they had got lower marks than the persons who were untrained. So the court said, how could you violate your own rule in the same selection process? And therefore, the court used those harsh words, illegal process of recruitment. Please come to note the 2 sentences at page 62.
that cannot be an answer to your fence sitter argument.
Please come to note page 61.
No, that we are not going into merit. We want to know why you will not treat you as a fence sitter. Finished.
Yes. No, please come to 2025.
2019 December was the order of the chairman. You did not challenge the same. Not even a representation made. You lost all your hope. এখন বয়স কত?
He approached this court after the division bench passed the order.
37 বছর বয়স 25 38
Now, please
what is your answer to this question? Then you, if you want to say anything, we will
please
take.
come to note paragraph 6 of the 25 judgment.
অন্যদিকে নিয়ে আছে প্যারাগ্রাফ 6
of the 2025 Supreme Court judgment.
2025 না 16 ডিসেম্বর
Judgment cited.
এই যে judgment-টা।
ও আচ্ছা
The candle.
ওই
Suprita.
দিলো ওই it
That
has
is-
been annexed.
That is employee, that kind of relief.
এটা তো ও দিয়েছে
না
No,
এটা ও দিয়েছিল আগেও একটা আছে দেখি
Suprita's candle.
না না you relied
এটা
upon
আপনি দেখুন প্যারাগ্রাফ 6টা আমি দেখি এখানে
এটা
একটু
কে দিয়েছে তো
এখানে একটু দেখছিলাম এই যে
গাওয়াই সাহেব হ্যাঁ
ইয়েস প্যারাগ্রাফ
প্যারাগ্রাফ 6
কোথায় লিখেছিলাম খুঁজে পাচ্ছি না।
Note I placed from paragraph 4. Note paragraph 3, not the for better appreciation. It is undisputed that the appellant could not qualify in the first 2 chances on completion of 2 years of service and 4 years of service respectively. On 15th November 12, her services were extended for another 5 years. By 9th March 2013, the appellant had completed 5 years of service and was eligible to avail of her 3rd chance, subject to age relaxation up to the full period of reckonable service. However, on 20th March 2013, amendments were carried out to clause 4 of the 1978 rules as amended in so and so, inasmuch as while para 4A was amended, para 4B came to be deleted. The amended para 4A of 37 of 78 introduced on 2013 reads as under. So the qualification was changed. The net result was that the appellant was deprived of her 3rd chance since the extension was capped at 35 years and was confined to those who were in receipt of PG qualification of masters in dental surgery on and from 2013. According to the appellant, officers similarly situated with the appellant who were also not given an opportunity to appear for the clinical test and interview, in view of the amendment, quickly moved applications before the AFT principal bench in OA number so and so and batch of 2013 OA and batch of matters raising various contentions and contended that they have been wrongly deprived of availing the third chance for no fault of theirs. Though the amendments to the policy were upheld, the principal bench granted relief in the following terms in the said batch of matters. The other contention of the learned, the quoted portion of the order. The other contention of the learned counsel for the petitioners is that the government can grant age relaxation in the given facts and circumstances of the case. It is right that the government has the power to relax the upper age limit if it is found that operation of the rule or policy has hardship on the persons working in the corps. Nothing has been shown that the government has no power to relax the upper age limit. Now coming to the question as to whether the operation of the policy has hardship, it would be seen that an exception was provided for SSC officers for giving the benefit by extending the upper age limit. It is also admitted by the respondents in para 41 of their counter that one-time age relaxation in the upper age limit has been granted in the case of an AMC officer who had joined as SSC officer prior to issuance of the impugned amendment. By deletion of para 4b, some of the SSC officers became ineligible for permanent absorption. The petitioners who were working in the corps continuously expected to be given 3 chances to seek their permanent absorption. However, due to impugned amendment, they have been denied these chances. Therefore, as one-time exception, the government can relax the upper age limit. In view of the above discussions, all 4 petitions stand partly allowed with following directions. Direction number 2. A direction is issued to the respondents to consider the case of the petitioners who are eligible in the year 2012 but became ineligible in the year 2013 for grant of permanent absorption on account of amendment of policy. Direction number 3. A further direction is issued to the respondents to grant one-time age relaxation in favor of the petitioners for seeking permanent absorption, as has been done in the case of AMC officers who had joined as SSC officer prior to the issuance of the impugned amendment. The entire exercise for consideration of the petitioners for grant of permanent commission shall be completed within a period of so and so months. Then paragraph 7 is the view of the court. According to the appellant, she could not join the applicants therein in the litigation as she was in her advanced stage of so and so, and while posted at Bareilly, she proceeded on maternity leave on 16th May 2013. The appellant delivered a child on 1/7/2013. Consequent to the order of the principal bench, permanent commissions were granted to officers who were eligible prior to amendment to avail a third chance but could not avail in view of the amendment of 2013. A representation submitted by the appellant on 2014 did not yield any favorable result and was rejected with the following endorsement. As per directions of the...
Facts are different, Mr.
Yes.
Jindal.
But there was a rejection, of course. Now come to paragraph 10. At the outset itself, we may say that the phrase only to the petitioners in the order rejecting the representation is patently erroneous. While the principal branch granted relief to the petitioners, it did not prohibit the department from considering similarly situated persons. Another representation was disposed of in 2017 on the...
There was no representation in this case.
Say that
we were asking that after 2019 December order, even if you have not challenged, did you file any objection letter?
Not, I've not put it in this way. Not when the court has declared a process or not
as bad.
As bad and
there are untrained candidates.
Illegal.
And there are untrained candidates working.
Please see the second paragraph of page 64, the division bench order. Please come to page 64 once again. Please come to 64 paragraph 2 once again. But the court probably called for the records and therefore it has written, we are convinced from the record that the learned single judge was justified in allowing the claim of the petitioners as they have desirable qualification and they should have been given preference. Then the next sentence, the candidates appointed are admittedly untrained. So that in that context, not the order of the commissioner has to be tested. But when the commissioner says that I did not possess, I was below the cutoff marks of the last appointed candidate, please come back to the order of the commissioner now. Page 16 of the supplementary.
That part ends, and it is admitted position that you obtained the lesser mark. That part's end. You didn't take that cause of action to the subsequent writ petition was filed. Subsequent writ petition or a fresh cause of action showing the appointment of HON'BLE.
Now, yes. Please come to page 17 of the supplementary affidavit. That's the order of the commissioner.
The 17 supplementary.
Page 17. That is the order of the chairman. Yes, what are you showing?
Please come to note paragraph 1 of page 17. No, the first page did not deals with the history of the litigation. I need not trouble your lordships on that. Although the petitioner numbers, there are several petitioners.
Petition has not been considered.
1197W of 2018 and petitioner number 4 of 2018 did not submit any representation. The commission had accepted their deemed representations through submission of the learned advocate for ends of justice. The main grievance of all the petitioners.
Wait, acha.
The first
Did not
paragraph of
submit
page
it.
17. Although the petitioner number so and so in WP number so and petitioner number so and so of WP number 2018.
Their case was also taken into consideration.
The commission had accepted their deemed representations through some submissions of the learned advocate for ends of justice. The main grievance of all the petitioners is that the commission had published 3183 tentative vacancies for SLST 2013 in different subjects, whereas the commission had only recommended in more or less 2000 vacancies, and as such each of the petitioners claimed that 1183 vacancies are still existing in the hands of the commission. The petitioners for that reason claimed for their recommendation for those 1183 vacancies. The commission had published 3183 tentative vacancies on 2014, and in terms of the order of 17th May 2018 passed by the Supreme Court of India in CA number so and so of 2017, the commission was able to recommend only 2570 candidates in different madrasas under different categories. The commission, although had published 3183 tentative vacancies, but could not recommend in all those 3183 vacancies on the ground that a good number of candidates could not qualify in 8 particular subjects either in the written examination or in TET, as per rules of the commission read with the guidelines of NCT, for which a good number of vacancies of those 8 subjects still remain vacant. As most of the petitioners are not the candidates of those 8 subjects, the said vacancies still remained unfilled at the time of recommendation. Although most of the petitioners were called for personality test in accordance with the rules of the commission, but they were below the ranking of the empaneled and wait-listed candidates in the final merit list in their respective subjects, for which their names did not appear in either the list of empaneled candidates or the
এই ইস্যুটা যেটা তুলছে সেটা কিন্তু এটা তখন তোলেইনি এই ইস্যুটা at that time your case was that tentative vacancy was declared of 2183 posts
3183,
but you have only appointed 2000 posts, so 1183 post vacancy are available. Give us the job.
Now, please.
At that time.
Did you take that point in the
At that time you did it.
No, this is not in the first round. Now, please. Paragraph that I was placing before your lord.
Yes.
For which a good number of vacancies of those 8 subjects still remained vacant.
Yes.
As most of the petitioners are not the candidates of those 8 subjects, the said vacancies still remained unfilled at the time of recommendation. Although most of the petitioners were called for personality test in accordance with the rules of the commission, but they were below the ranking of empaneled and waitlisted candidates in the final merit list. I pause here for a moment. This now has to be now revisited in the light of the declaration. In their respective subjects, for which their names did not appear in either the list of empaneled candidates or the list of waitlisted candidates. Therefore, the claim for recommendation in rest 1183 vacancies as per their representations has no basis or foundation on the points or grounds as discussed herein above as per rules of the commission. The claim for inclusion of vacancies up to 5/9/2016
okay, whether you raise this issue or not.
Where is the order passed in the earlier writ petition page? Did you raise this issue before?
No, it was never. Page 50.
Page 54 of
No, that was page 108. Page 108.
108.
Akmol ও ছিল। You are not party to the writ petition filed by Agmol in 2019.
No.
No. 2018 writ petition.
Kazi Sawaz. Acha, there this point was asked
Not
that
at all, sir. Please come to page 108. Where B. But I read not the first sentence. 190 similarly situated persons have joined together in these two writ petitions for a common relief, and the same is quoted below. Please have a look at prayer B. A writ of or in the nature of mandamus directing the respondent commission to fill up all the vacancies which have cropped up till September 5, 2016, so that the petitioners are rightfully appointed as assistant teachers under the said commission. C. Mandamus directing the respondent commission to include all the willing madrasas and disclose their vacancies for appointment of teachers in terms of the orders passed by the Honorable Supreme Court in 2018. Prayer D. Mandamus directing the commission to include the vacancies as on 5/9/2016, the date on which the written examination was declared, and appointment to be given to the petitioners on the basis of the said vacancy.
Reference point was never there.
Prayer E. Please come to prayer E. A writ in the nature of mandamus directing the commission to prepare list of all qualified candidates who attended in personality test and retain them in the panel so that the existing or incurred vacancy could be filled up from the said panel in terms of Rule 24. So, Lord, that qualified candidates have to be appointed in terms of exposition of Rule 24 of the rules. This was very much an issue. Now, please come to page 109, the paragraph just after the quotation.
So, what is Rule 24?
Please come to the rules. That's
Rule 24.
That's page 61 of the note.
Rule 24 is the expiry of the panel within 1 year. That's all.
Oh.
Validity of the panel.
But I have said prepare the panel in accordance with the rules.
Yes, that's what I'm saying.
No, I'm saying that's there.
24 is nothing but 1 year.
No, I've said in accordance with the rules. Rule 3 is giving preference. And my prayer is appoint me legally in terms of the rules.
Everything then comes under legal.
It is expected that when a court of law has found an issue to be an action to be illegal, not the commission as a Article 12 authority would rectify its mistake insofar as petitioners are concerned at least. Now please come to page 109, the direction. In the meantime,
so where is your representation of 27th March 2019, which was directed to be considered? Page 110, second paragraph of the order.
In the meantime, the following petitioners have been granted appointment for a separate post other than the posts connected to those writ petitions. They are so and so. Thus, it is prayed on behalf of the said petitioners that they do not want to contest the instant proceedings as they have already been selected. It is contended on behalf of the other petitioners that as there are existing vacancies and some of the petitioners are waitlisted candidates, and as such they should be given a chance for being considered for appointment. Learned advocate appearing on behalf of the commission submits that as the petitioners were unsuccessful in the personality test.
A separate cause of action, raising separate plea. এই যে জায়গাটা সেইটা এখন এই 25-এর জাজমেন্টে কি রেফার করে কি ফেরত পাঠানো যাবে?
25-এর জাজমেন্টে তো পাচ্ছি না কিছু, এজ রিল্যাক্সেশন কিছু ছিল
না। 25-এর এই যে জাজমেন্টটা এইখানটা 16টা মেরে দিয়ে গেছে, এই 14 এবং 15টাকে
14-15 বেল সেটেল, আদার্স ইউনিয়ন এক্সটেন্ডেড, এখানে ঢুকে যাচ্ছে।
ওইটাকে যদি আমি কেটে দিই তাহলে আমি ফেরত পাঠিয়ে দিয়ে যে ওরা ওই বেনিফিট গুলো পাবে। বেনিফিট অর্ডার অফ বেনিফিটটা দেওয়া যায়। তুমি তো পাঠিয়ে মেরিটে ঢুকো, তুমি ডিলে করেছো।
ডিলেটা হচ্ছে কি, ডিলে আমরা কন্ট্রোল করি না জন্য
সেটা হচ্ছে 8টা সাবজেক্ট, দেখি 8টা সাবজেক্টে পড়ছে।
Do you come within those 8 subjects?
8 সাবজেক্ট, হ্যাঁ,
I come within those 8 subjects, history.
হিস্ট্রি।
And the vacancies which were,
Next
they said,
SLC is also over.
that has been sent up to the next selection process.
Carried
Right?
forward to
Process
next selection
done,
process.
that is also over. Next, I'm saying.
That has also.
Yes. Otherwise, why should I take this point? Because every single vacancy, it's not a vacancy. The order of the Honorable Justice Gangopadhyay was that if someone has to lose, he will lose.
No, protection given. Justice Gangopadhyay said, don't disturb.
No.
Yes, kindly come to page.
Disturbance was there.
Kindly come to his lordship's order.
No, protection was
61.
protection only in contingency protection.
No.
Kindly
So,
see.
wanted those who have
I'm reading, my lord.
appointed.
Coming to page.
Can you do not have desirable cause and recommend
No.
Within a 15 days.
If necessary, the untrained candidate service may be interfered with. So no protest.
You see the next sentence.
So
If the petitioners can be accommodated in vacant
exactly,
posts, including posts.
Yes, that's why I'm
from
contingent.
future vacancy.
Yes.
For which steps are to be taken forthwith by the commission for obtaining such vacancy.
Yes.
And in such case, the petitioners are to be appointed in such posts without disturbing.
It is contingent, and future
Other persons
recruitment
who
is
do
also
not
over.
have training qualification, that is desirable qualification.
So every appointment means losing of somebody, and next recruitment is also over. That's what I'm saying. And in fact, nothing to do with this point. The division bench judgment, the division, don't take it as for officially, the division bench judgment of our court holding that when there are identical marks, you must give preference. But someone lesser marks, no. That was argued by the Honorable Court while as an advocate. It was it continued for several days. Incidentally, I also appeared in that matter. And that division bench was never placed anywhere.
Which division bench?
There is already a division bench judgment of our court specifically holding what is the meaning of preference. And the division bench held.
Argue that before the
No,
court.
that is not required. That is not required.
We are not on that.
Yes.
No, you
only delay.
read the order of Justice Gangopadhyay once again.
Yes.
I direct.
May I read it?
Yes.
Why I say it is personam, it is not a rem.
It is in this selection process.
Yes, correct.
It is binding upon you.
Yes, it is binding.
Yes.
Agree.
Yes, yes.
I direct the commission to give preference to the petitioners first, not to the candidates. Over the candidates who do not have desirable qualifications, and recommend the names of the petitioners, again, petitioners on, in the post for which they have applied within a period of 15 days from the date of communication of this order. If necessary, the untrained candidate service may be interfered with for accommodating the petitioners. Kindly mark this.
Petitioners.
It is nobody, not everyone having that qualification, who have been deprived from.
Who have been deprived
Yes.
from service.
Who petitioners then qualified, not candidates qualified. That it's two different things. And division bench put a seal to that. I could have understood the division bench have opened up the petitioners to all candidates. No, now there is, I would say that the judgment they are referring to as if against me, it's not against me. The judgment originally being limited to the petitioners, the moment that is affirmed by not interfering with, there is a seal of the Honorable Division Bench relief was restricted to petitioners and petitioners only. Despite the word candidates being used.
সুপ্রিম কোর্ট দেখলো না, এবার এ বলছে যে এটাই যে both this judgment is specific to the petitioner there too. না অন্য, আর এখানে গল্পটা অন্য, এখানে আকমল না, আকমল হবার পর এরা এলো।
When the earlier writ petition was preferred, in which it was relegated to the council,
Right.
that writ petition was banking on the rules. That same rule is here.
Yes, but nothing to do with this point.
No, your argument is that this point was not urged in that writ petition.
Yes.
So you are urging this point only after declaration by Supreme Court.
after
That's why
division.
you are a fence sitter.
Yes.
From 2020, from 2019 till the order of Supreme Court, you had been a fence sitter.
Yes, yes, yes.
Now, but you have to consider that, was it in respect of a totally alien subject? It is pertaining to the same rule. When I filed the writ petition in 2018,
yes,
I had no idea that this rule is bad.
But I have a very interesting response to that.
Yes.
Here his case gets even worse. I could have understood that I am waiting. Someone who challenges, can you consider? He is aware about the rule.
Yes.
That awareness goes to December 19.
He has not challenged the rule.
No.
There it was vacancy.
No, I said that ultimately his awareness, whatever, law, preference, that.
No, not awareness, Mr. Dhar. If you had been the writ petition at that time,
yes,
you would have framed the case that, see, I have got more marks, there are vacancies, you please consider my case. This was my argument.
Correct.
Why should I consider? Because I have participated in the selection process pertaining to that rule.
True.
Now in 2019, council chairman says, no, there is no vacancy.
Right.
And you secured lesser marks, so you are not coming in the party.
Correct.
That was in 19.
Yes.
Now in 2022,
yes,
court says the rule is bad. So court is declaring a rule which was existing on the date of my consideration.
But there are two things. Court is declaring a rule is one thing. And thereafter court restricting the relief to petitioners only is a different thing.
Different thing.
But here that different thing happened.
But in that case, how can you say that strictly speaking he is a fence sitter?
Because of the reason that from 19, kindly take it that when he gets to know about Justice Gangopadhyay's order, 22, he doesn't even file then also. I can understand that he files a writ petition saying, look, some relief have been given to petitioners. I am identically situated. I am also filing a writ. He does not even file that.
But Mr. Dhar, Supreme Court said, confirmed that untrained persons have been given. That was before the Supreme Court.
The Supreme.
If today suppose I am passing an order on the basis of a rule, believing that rule to be the guiding principle.
Right.
Now, after 5 years, my brother sitting in a different bench comes to a conclusion that rule which was there in 5 years ago, that rule itself is bad.
But that has never been said by any court. That is the problem.
We are only on the.
That is the problem.
Please have a look at
because
number C in
that
the
you restore your strength and
that has never been said.
Restore.
But kindly, but I have kindly do not hear me on.
After expiry of panel, your panel expired in 2019.
Yes.
In 2024, where from you got the vacancy to accommodate Agmal and such and such?
That's my.
So vacancy you have.
No. Kindly look at this way. That's a reverse engineering. That's reverse engineering. That's reverse engineering, my lord. If there is a judicial directions, I have to. For that, if I have to dislodge anyone, if I have to cut it out from this next selection, I have to do, because that's the institution leaves.
No. Court has said that if there are vacancies, very good. You can adjust those vacancies from the future.
What happened? The next SLST.
Have you handed over this judgment to Mr. Dhar?
This Suprita Chandel.
Yes.
I have the Suprita Chandel maternity leave, employer-employee, and lastly Article 142. I have read it. I have placed it before your lordship also several times.
At the outset itself, we may say that the phrase only to the petitioner in the order rejecting representation is patently erroneous.
Yes. Kindly see in what context.
So,
no.
Mere use of the word to the petitioner may not be specific. Now you come
in the context of an employer-employee relief.
Okay. Now come
not in recruitment.
Para 16.
Yes.
Whether now it is to be considered whether merely use of the word to the petitioner.
Yes.
Whether a right in personam has been determined.
Yes.
Or right of all candidates have been
Yes.
determined.
Yes. That's
Or a
that's
section of the candidate has been determined.
Yes,
Or not. You come to para 16.
yes.
Whether grievances in personam is
Yes, I'm
yes.
coming.
Para 16.
Para
In fact,
16.
I'm reading.
Only to the petitioner, very much.
In fact,
The court
one
has
of
used
the
the phrase only to the petitioner.
one of the very fundamental principle
Eh.
of not granting relief in a classic case of fence-sitter. Two things lordships always deal differently. One is what is the correct law and what relief versus whether it can be applied and relief can be granted to person who is waiting and watching. In a recruitment process, waiting and watching, that's fence-sitter, is extremely applicable because here the context is panel. And there are n number of judgments.
No. Actually, had they approach
Yes.
before expiry of panel, they would get. And if at that time this judgment would come, judgment or order of Justice Gangobadhyay, Division Bench judgment and Supreme Court, they would got. You are going to penalize them only two reasons.
It's not
that you have not approached before expiry of panel.
Yes.
And that are, even after this year, you have come
Yes.
after 5 years.
Yes. Because, may I say why? Yes.
Even you have come after 5 years.
Yes.
And hence you are penalized.
Yes.
You shall not be given the same benefit.
Yes.
Although it was extended to the person similarly situated to you.
No, it was
for your belated approach.
No, may I say? Kindly take my note. Why? It's not me. Why so? I have to the first page, the 2010 judgment.
Yes.
That's the Raj Kishore.
Hmm.
I'm Lordship read it here. It's just a quote. Paragraph 16. A select list cannot be treated as a reservoir for the purpose of appointments. That vacancy can be filled up taking the names from the list as and when it is so required. It is the settled legal proposition that no relief, Lordship may kindly mark this, declaration and relief, two different things, can be granted to the candidates if he approaches the court after the expiry of the select list. If the selection process is over, select list has expired and appointments had been made. And in this case, not only this, next selection process, that is also over. And then next 24, the aforesaid view taken by the High Court cannot be held to be in consonance with law. More so if the state has committed an error in preparing the merit list containing the names of the candidates double the number of vacancies determined. That would not mean that the select list has become immortal and all those persons whose names appeared in the list would be offered appointment even after the expiry of the life of the select list. Kindly see following this 24th judgment in Ali Hossain Mondol, paragraph 10. It is then argued that the life of the panel merit list remains valid for a period of 1 year from the date of approval of the board. In this case, since the panel was notified on 15th of February 21, it naturally expired after 1 year, that is on 15th February 22. In this case, candidates filed their writ petitions only, kindly see only in May 22, kindly pause. So there was a delay of just couple of months.
Yes.
Unlike this case of 4 or 5 years. That is approximately 3 months after the panel had expired. Therefore, no individual could have claimed any right of appointment in reference to the particular recruitment process after the panel had expired. In fact, my lord, in this Boishakhi...
Pertaining to a valid rule, not an invalid rule.
No, correct.
Here the rule itself is not valid.
My lord,
why should we close our eyes?
My lord, rule...
The rule which you have followed,
Yes.
that has been said by the division bench as well as the point which you took.
Yes.
That where is the
My lord,
division bench?
Division bench.
That's page
is
64.
Yes, division bench have actually said nothing excepting we don't.
Untrained teachers.
Madam, may I kindly come to division bench at page 64? May I place division bench?
Yes.
Kindly see that we have convinced from the record that the learned single judge was justified in allowing the claim of the petitioners. Kindly mark that. That's why I said this is a seal of the division bench, only to the petitioners. As they have desirable qualification and they should have been given preference over the candidates who do not have desirable qualification. The candidates appointed are admittedly untrained.
Where in the recruitment rules, where do we find that desirable qualification?
Yes, my lord, that if lordship enters into the, yes, that is there. My lord, it's, that is, in fact, lords, I kindly take my note. I have given also.
No, this one.
Yes. Kindly take page 10.
Yes.
Now that 10 is, I have not quoted it. Lordship has to, just a second.
May comprise a written test plus other scored components. 8 to 5 minimum.
1 is, my lord, the selection may comprise written examination plus other scored components. Rule treats the written paper as one of the mark bearing segments. It's not qualifying. Now rule 8.2, commission may fix a minimum qualifying mark for the written paper in addition to the aggregate cutoff. Qualifying bar does not convert the paper into a pass-fail hurdle. It merely excludes those below the threshold, after which the, my lord, the actual marks continue to count towards merit. Now, rule 17, my lord, scripts are evaluated, marks are tabulated, and this makes only sense where, this part is my.
Where is the desirable word?
Yes, my lord, that is, lordship will find. And 3. Rule 3 proviso.
Rule 3 proviso?
Yes.
That is in your note, Mr. Dhar?
Yes, my lord. It is.
Page?
This one.
Okay.
61. Yes, where is it? Where do you find the
61 clause B?
But I have a separate copy of the rule I'm giving.
One of this combined written. Oh.
Yes, no,
The lordship need not go into the, I have a separate
Please
copy
come to page 61 or Dawash.
rule there separately.
Please come to clause 3 under chapter 2. The name of the post and its qualification shall, have your lordships got that? Subject to rules 4 and 5 be such as specified respectively in columns 2 and 3 of schedule 1, provided that a person having the desirable qualification mentioned in column 2 against the post mentioned in serial number so and so of schedule 1 shall, if qualified in written examination, get preference over the candidate who has qualified in written examination but has no desirable qualification.
So you qualified in the written
No,
test.
please come to the proviso. Provided that the person who is already in approved service in the sanctioned post of teacher or non-teaching staff of any madrasa or school may apply to the. No, it's not necessary. That's
or
true.
not necessary.
That is not.
So you applied, you participated, you
Yes. Now please come to
written test.
Yes.
Then
Now
you were
please
called for interview.
and personality.
You were called for interview.
Yes. Yes. Now and personality test as also.
Now thereafter you were waitlisted.
Not recommended. Now please.
No, you were not in the panel.
That's because I was not recommended because of not other persons occupying higher position.
But you were there in the panel.
No. I was
But
not.
kindly take the marking.
Candidates were placed in the panel.
No, not only untrained. They are the person with the B.Ed. The last person with the
There were
B.Ed.
trained persons, there were untrained persons.
Got 66.31.
Page 74.
You will never come. Maybe some others will be, if lordship.
That is the last mark.
That is the last marks I am saying with B.Ed.
No qualifying marks has been fixed.
No, may I say this? Kindly take 2 marks.
Had there been any qualifying marks, the 60 or 70.
No, I am saying the petitioners will never come because, kindly give me 1 minute. Kindly take the marks. Last person with B.Ed qualification 66.31.
Where is that page you should have? Which
But that's in the in page number 4 of my note. That's
But page rule 3 has to be read without with the
just
schedule.
just give me a moment. Only take page 4 top
page 4
of my note that I was.
No, where is that RTI? Show us na.
No, that is the same thing. Lordship will get it directly. That's the same thing.
No, we marked that na. Your
Oh,
opposite.
sorry.
RTI, Axmal or anything like
Where
that.
is your RTI?
That is page 19 of their supplementary evidence.
84.
My lordship need not see it. This is cumbersome.
No, he
Kindly take the marks. Last person with B.Ed 66.31 and last person without B.Ed 66.87.
Where you are reading? Lowest weight
And he got 63.83.
63.83 in the subject of
history, postgraduate. That's the subject. 63.83. Now his
the last candidate was
last candidate, like him, who also has the B.Ed qualification, got 66.31. And the last candidate, without having B.Ed, got 66.87. It's a huge difference.
But probably not. We are
Of course,
some come to the your lordships are considering the rules. Please come to page 61 and 70.
Rules is a different thing. Rules is a different thing.
So you were called for the interview, but ultimately you did not find place in the panel. But you obtained total 63.81 marks. That is written plus interview.
Yes. There are many candidates who
Just
have
a one. Now the last M-panel candidate who was appointed secured 66.31.
Yes.
But you scored lesser than that. You were lesser. Higher marks were appointed.
No, yes, no, that's where not the honorable court stepped in interpreting the
That
rule.
you have to give training. Now, if you give training, you have to give preference. Marks, how much, that is not court did not say.
Agitated before the
That
was
divi-
agitated.
Sir, whoever got training.
Yes.
That was
And,
this
he-
was agitated.
and completely, my lord, ignoring the other division bench, holding that when it is identical,
unsuccessfully before the honorable
in
Supreme
case of
Court by the
identical,
commission.
both persons are getting identical marks, then you give preference. Division bench judgment.
But this was unsuccessfully agitated before the Supreme Court by the commission. Please see ground number C in the SLP.
We have extensively heard Mr. Bojumdar, learned senior advocate, assisted by Mr. Bose, learned advocate appearing for the appellants, and Mr. Dhar, learned senior advocate appearing for the commission. Is the matter as for orders in the daily supplementary list of this court on 17th at 1.
Fine.
I have an application for intervention.
Well, this copy.
আরেকটা পরোটা শেখেছি না
Well, the judgment referred, the copies, I believe, I have not given, because the judgment that I have referred, kindly take it that I have given.
Yes, you
So I have not given copies. May I hand over the copies?
Give it.
I'm giving.
Citation now.
So many.
2010. I prepared long back.
Max to max, we will send it back. You will argue on merits. What is the problem?
But there are hundreds and hundreds are there having much better marks.
They are waiting.
Yes,
They are also.
his marks is 63. Is actually, and this in the context of Miller, this panel, kindly visualize, It will be another.
Have we said give him appointment, Mr. Dhar?
Of course, Malik.
63 to 65 বোধ হয় 100 কি হাজার করে বোধ হয়।
সেটা বলি।
হ্যাঁ।
Now
The application for intervention. Not only two.
File fresh
Writ petition is there, Mlad.
Very good. Why you are interviewing?
Since Mlad, this issue is being decided here, Mlad, sir, I have.
No. This is you are intervening. We don't know what is your
But
period of.
I have my writ petitions, Mlad.
Your case, you did not file writ petition. You have
Yes.
filed the writ
Yes,
petition.
yes.
So we will say you will take the help or not the help of.
Either way.
Hello.
Since you are deciding the points of law, that's
No point.
I'm joining here.
We are not deciding on merits. We have told that we
Only
are,
on delay for this.
whether we will be stopped on the threshold or not. Only that.
Even if your lordship dismiss the appeal, Mlad, then even then, Mlad, I'll be affected, Mlad, by the lordship.
Why you will?
Because the same point they will be taking, Mlad.
Your point is delay point.
Again, delay is an individual thing. But delay is individual. It's delay is individual.
You said if we hold against
Well,
Mr. Dhar, show our.
In fact, the similar facts, first round of litigation, then 2024.
আমি আর ভালো কেস চল ইন্টারভিউ
এই জাজমেন্ট গুলো কি হলো?
3 PM fixed matters.
ওরে ওটাতে বলে দিয়েছি।
Well, the judgments are be handing over to Lordship's court officer.
Reported, you have given
citation. Handing over to the court officer.
আচ্ছা ওটা দিয়ে দাও না।
দিয়ে দিন, হ্যাঁ।
Malik, 3 PM fixed matters will be taken up tomorrow. 3 PM fixed matter. I've been waiting. Mr. Shanal was also waiting.
Your Lordship, I appear for the state, Your Lordship, in this matter, item number 8, Your Lordship.
We keeping it on 13th at 2 PM.
No, not 13. Not 13. Not 13. That tomorrow, natural usual course, my lord, let those appear.
No, tomorrow we have other matters also, Mr. Lairi. Let us see how we.
After 17, item 17 and 567.
568.
568.
7 and 8, Your Lordship.
May.
Any day, my lord. Any day, any subject to lordship's convenience. It will not take more than 30 minutes, my lord.
Come on 13th. We will give you 3:30 PM.
ঠিক আছে, আর আমাদের বেসিক্যালি আছে দুদিন,
Any day.
4 দিন।
My brother won't be there.
I will be in circuit since 20th. So we have 4 days. This bench has
any day.
4 working days.
Your lordship is already
My
hard.
brother won't be there.
Your lordship has already hard that matter. Just wait.
ওটাকে কত নম্বর?
17, item 17.
17 আর 5 থেকে ওটা।
5,
Yeah,
6,
5 to 8, Your Lordship. Item number 5 to 8.
মে মাসের 5 তারিখ রেখে দাও। মে মাসের 5 তারিখ।
ওটা ব্যাটারি শেষ হয়ে গেছে।
5th May.
5, 6, 8 also.
Just after the day.
5, 6,
8.
5, 6, 8 and 5, 6, 7.
Oh, 5th May.
7, 8.
Only one thing to inform your lordship that board is allowing 5 years. Below 5 years. They're allowing transfer. So nothing remains after that.
Then why you are insisting?
That is why I'm praying for disposal of that.
Oh, that Mr. Sannal has not.
ওটা আমি সান্নালকে বলে।
We have told Mr. Sannal
We have told this thing, Mr.
that you
Sannal.
give a thought to it.
Yes.
Give a thought to it. In that case, our burden will be less.
Board is allowing. Board is allowing.
Huh?
Board is allowing transfer below 5 years.
You have a talk with Mr. Sannal. We don't have any problem. We will dispose it on that ground only.
Let it appear.
They will consider, if they say that we have given mistakenly, we have given that cannot bind us, let them say that in the order, let them pass an order. But if he opposes that, no, I will have it matter determined, then it will take time, no?
5th May as of
5th May, but you talk with Mr. Sannal. We have already had told Mr. Sannal that you please consider this, that as in similar cases, this stand has been taken. Then what is the problem?
The honorable single bench is also passing the orders. They are not opposing.
Yes, you have a talk.
Your Lordship is fixing any time, Your Lordship, on 5th?
Time fix করলে